Good morning, everyone.
Good morning.
Good morning.
Good morning.
Hi.
Yes, good morning, everyone.
Good morning.
Morning, my lady.
Good morning, my lady.
Thank you, Ms. Oswald.
Morning, Judge.
Tuesday, the 3rd day of August, 2021, called via Zoom at 10:05 a.m. before the Honorable Justice Sabir Williams, Civil Jurisdiction 2020, number 474, Ewart F.Brown Jr. versus the Department of Public Prosecutions and others, Mr. Delroy Duncan, QC, for the applicant, Mr. Jerome Lynch, QC, for the applicant, Ms. Elizabeth Christopher for the first respondent, Mr. Brian Moody for the second respondent, Mr. Mark Deal for the third respondent, and Mr. Alan Richards for DPP. Thank you. Yes. Shall I look towards Mr. Lynch first?
I'm sorry, my lady, just to interrupt. I do apologize. I don't want to stop my lady friend, Mr. Lynch, but unless I missed something, the only matter that was just called on was the constitutional matter, whereas I think that you have
I
both.
think it is proper, yes, for the criminal matter to be properly called.
Yes.
She's referred to the applicant and the respondents. I think she's tried to do it as succinctly as possible, but I can just for the record state that this is obviously the civil constitutional matter, but this is also the criminal proceedings, and the application will be heard simultaneously between both matters.
Thank you, my lady.
My lady, I have one procedural note just for the record that is not of any great moment, but I think I should make it. By order of the 25th of June, you merged the recusal application in the criminal proceedings with these civil proceedings.
Mr. Duncan, can I ask for you to just raise your voice somewhat, only because I'm struggling to hear you against the, it may not be you, it's a background, I'm afraid, on my side. The air condition is pretty loud, but to turn it off would be pretty uncomfortable, I have to tell you.
Right. Yeah, I just checked my volume is on 100%, so
Okay.
I can't turn mine up anymore. But I will just say this. So by order of the 25th of June,
Yes.
you merged the recusal application in the criminal proceedings into the civil proceedings. And in that order, there was a requirement that the respondents file any submissions in response within 7 days. You may
You have
recall,
leave to file submissions, yes.
within 7 days. The first respondent filed submissions on the 23rd of July. That was 3 weeks out of time.
Yes.
And by an email dated the 2nd of August, the third respondent did not file any submissions, but said the following, just for the record.
Yes.
In relation to our position on recusal, this is essentially a matter for the learned judge, but the paragraphs cited demonstrate the court's approach in this jurisdiction to issues of appearance of bias, and is noteworthy that a recent former partner of a firm, the Chief Justice, who was a long-standing client as a party to the proceedings before him, is not of the view that there is or was an appearance of bias in that case. And that's a reference to the Siddiqui case that is probably going to be one of the authorities that you're going to hear today.
Mhm.
Our position is that we take no point with respect to the late service of submissions by the first respondent. Indeed, we take no point with respect to the fact that the third respondent has filed no submissions. We assume that his submissions will be limited to the comments he's making about the Siddiqui case, which my learned friend, Miss Christopher, intends to rely upon. The only reason we make this point is that we want it for the record noted that we have taken no objection. Should the issue arise in future, we're hoping that we will get the same latitude from the other side.
I see. Thank you, Mr. Duncan. Anything arise out of the points made by Mr. Duncan? Mr. Deal?
Solely, milady, that as my learned friend is well aware, in other applications, in fact, before your ladyship, the same latitude has been already extended to my learned friend.
I'm sorry.
And of course,
one moment, please.
To screen sharing for some reason.
Can someone explain to me what's happening?
I think Mr. Brown, Dr. Brown is sharing his screen
Yes.
Sharing his screen
with everybody. By mistake, no doubt.
I'm sure it's an error.
Yes,
is that an error that we can fix because it's come up on my
Get
screen?
it back where it was. Just a moment, I'm sorry about that.
That's fine.
In any event, lady,
Correct.
I'm grateful for my learned friend's indication, but the only point I would wish to make is my learned friend in previous proceedings of a similar nature involving similar parties has under the guise of, quote, attempting to assist the court, made submissions, which of course we did jump up and down a little bit, just as my learned friend is doing. But certainly it's a latitude, I'm grateful for my friend, it's a latitude we will of course extend to him in the future if should he require it.
That draw an end to the preliminary observations made by Mr. Duncan.
I'll keep my powder dry until such as it is, my lady, till after my friends have finished making their submissions.
Can I, at the risk of trespassing on your ladyship's patience for just a moment longer, make one other?
My patience is long today, yes.
Thank you. I have had a brief discussion with Miss Christopher, who, as you know, appears for the director in respect of the civil constitutional proceedings. And it seems to me, respectfully, in light of the fact that she has filed some quite extensive written submissions in response to those filed by Mr. Lynch and, as I understand it, adopted by Mr. Duncan, that it may make sense, subject obviously to the court views, if Miss Christopher replies first once Mr. Lynch and Mr. Duncan have spoken on behalf of Dr. Brown, because although I think I said on the last occasion that I don't have the habit of being brief, I can probably be very brief if Miss Christopher has spoken first, because I probably am not likely to have very much to add to what she is going to say. Now, my understanding is that she doesn't object to that, having spoken to her. I wouldn't have thought anyone else would, but obviously...
Non-sensible. Is there any issue arising from this?
No.
Okay, so we can proceed with Ms. Christopher to respond immediately after Mr. Lynch.
Yeah, the only observation I would make is that I did not believe my submissions were out of time, insofar as I understood that if I were to file additional evidence, it had to be filed within a week. I am just trying to look for the draft order that my learned friend, I think, sent to the court yesterday, but it appeared to me that it was within the time. If it wasn't, I apologize, but at least I've tried to give due time to consider it for today's date.
Okay, thank you. Can we start? Mr. Lynch, you are not audible. It doesn't appear that you're muted, but I do not hear you.
If it pleases you, my lady, while Mr. Lynch, Queen's Counsel, works out his audio problems, I just wish to indicate for the record, you will see a link for AG's chambers. If you recall, I had informed the court that I would be outside the jurisdiction. I'm being supported by Crown Counsel at chambers in the event anything needs to be done. And with your permission, I've asked Mrs. Sadler-Best to monitor this as well. So she is on through the link marked as AG's chambers.
Thank you. Mr. Lynch?
Can you hear me now?
Yes, I can. Thank you.
Good. I hope that works better. If anyone's having difficulty hearing me, please just say so straight away.
I can hear you very clearly. I can hear you more clearly than I've heard anyone else so far.
Marvelous, marvelous. Well, this is, as I say, our application to which everyone has been joined. And like everyone else, I take no point on any late service. I've seen everything that needs to be seen by those who wish to make submissions, apart from Mr. Deal, who no doubt will elucidate upon any submissions he makes in due course. We have three preliminary points that we would like to advance. But before I do that, can I just say that your ladyship will see that we have, as part of the defence team, Sir Elliot Motley and Mr. Loof from the United Kingdom, both who are observing today. But in relation to our application, there are three matters, as I say, we would like to explore in the first instance. This is an application that your ladyship should recuse yourself. Not because we suggest there is any evidence of actual bias, but because what we submit is that there is the appearance of bias, and that the fair-minded, informed observer, considering the relevant facts, would conclude that there was a reasonable possibility and a real possibility that the court was biased. We, as you'll appreciate, made an informal application for your ladyship to consider recusal on the 21st of May 2021, in accordance with what has been identified as best practice by the Court of Appeal in the United Kingdom on these applications in the case of El Faraji and Faraji. And it is instructive in our respectful submission to just remind ourselves of what it was that the court there said by way of a postscript to the case. And your ladyship will, I hope, have an electronic file containing all the authorities that we seek to rely upon.
I do, but what I'm looking at, I believe I do. I recall having seen it. What's in front of me now is the hard copy binder that was filed with all of the, I beg your pardon, limit.
Right. Well, then that should be the first case in that bundle.
A moment. Mr. Lynch, I'm just going to ask for some assistance just for a moment. I'm going to stand on just for a couple of minutes, okay?
I can put it on the screen if that would help.
I've seen it already on my screen. I'd actually rather have it in the format that I
understand that. You can mark it then yourself. I understand.
Just one moment. Thank you. Okay, I have it. Yes, thank you.
The citation is, the neutral citation is 2007 EWCA.
Sorry, which case are we looking at?
We're looking El Faraji and El Faraji.
Yes.
Should be number 1 in your bundle.
Yes, I have it.
And it's the citation, as I say, is 2007 EWCA Civil 1149.
Yes.
The case is unfortunate in that the trial judge in a civil family matter used how can I put it, inappropriate phrases in describing one of the protagonists in the case, relating to his religion and the fact that he was a sheikh from Egypt. That perhaps doesn't matter too much for these purposes. If you turn to paragraph 32 of the authority, there you will see what is described as a postscript, having considered the unfortunate case. Mr. Lord Justice Ward, together with Lord Justice Mummery and Lord Justice Wilson, all agreeing, said this: "It is an embarrassment to our administration of justice that recusal applications, once almost unheard of, are now so frequently coming to this court in ways that do none of us any good. It is, however, right that they should. The procedure for doing so is, however, concerning." And I pause there for a moment because the court that the judge is describing there is the Court of Appeal. And he was concerned that the number of cases coming to the Court of Appeal was because judges weren't recusing themselves, perhaps more readily than they should, and so that it found itself in the Court of Appeal. And he goes on to say this: "It is invidious for a judge to sit in judgment on his own conduct in a case like this, but in many cases there will be no option but that the trial judge deal with it himself or herself. If circumstances permit it, I would urge that the first informal approach be made to the judge, for example by letter, making the complaint and inviting recusal. Whilst judges must heed the exhortation in Lockerbale not to yield to a tenuous or frivolous objection, one can with honour totally deny the complaint, but still pass the case to a colleague. If a judge does not feel able to do so, then it may be preferable, if it is possible to arrange it, to have another judge take the decision. Hard though it is to sit in judgment of one's colleague, for where the appearance of justice is at stake, it is better that justice is done independently by another, rather than require the judge to sit in judgment of his own behaviour." Our submission is that it's not too late to do just that, as I indicated in the written submissions that we sent to your ladyship back in May of this year. This application is being made at the very outset of a trial. It is not, as it were, that the issues surrounding potential recusal are something which arises only during the course of a hearing or when it becomes clear that there is some connection between parties that would otherwise not have been immediately obvious. This is an application being made at the very outset. And it is in that regard that we submit that it is entirely possible, and in accordance with what we have described as best practice, that this is something that could properly be dealt with by another judge, if only to determine whether your ladyship should sit or not. That is our submission. I've made that submission before, and we submit that the the exhortation in this case is one which the court should adhere to. It brings me to what I described previously as the precautionary principle or the precautionary approach. And your ladyship will have that well in mind, because it was part of the submissions that we made in writing, which are subsumed in the skeleton arguments which we put together for this hearing. Paragraph 2 of our skeleton argument, which I hope your ladyship will have before you,
Yes.
deals with the case of the AWG Group Limited and Morrison. This was an authority which, as identified there, and I don't think I need to turn up the case so much, because the matter to which I wish to refer it can be put into a very short compass. The case involved a 6-month civil trial where the application for recusal was taking place right at the very outset, as in our case here. Obviously, the parties were anxious to proceed, having set aside 6 months in order to do so. It is perhaps unfortunate that in that case, it was done only, I think, a week or so before the trial was due to start. Of course, very considerable costs were likely to be incurred, as here. It was clear from that recusal is not a case management decision. Either there is a proper basis for recusal or there is not. But the quote that I seek to bring to your ladyship's attention, we set out in our skeleton submissions on page 2 in paragraph 2. Where the hearing has not yet begun, there is also scope for the sensible application of the precautionary principle. If, as here, the court has to predict what might happen if the hearing goes ahead before the judge to whom objection is taken, and to assess the real possibility of apparent bias arising, prudence naturally leans on the side of being safe rather than sorry. We commend those words to your ladyship. This is a case in which the defendant here is not legally aided. Very considerable costs are likely to be incurred in the course of any defense he might advance to the extensive indictment that has been placed before him and this court. There are other judges who could hear this case. And should another court rule that you should have recused yourself, then those very considerable costs would have been incurred. And you will appreciate, my lady, that certainly from the criminal perspective, we have no right of appeal at all to any decision you make. So that if, for example, you were not to recuse yourself, and we find ourselves having to proceed to a trial that may last many months and at very considerable cost, only to then have to make that application in the Court of Appeal at some later stage. In our respectful submission, that would be a travesty. Dr. Brown will have to realize assets in order to properly represent himself before any court on these criminal charges. So we do seek to persuade your ladyship that the precautionary principle, coupled with that which is best practice, is in our submission the right way forward in this case. And if there were the slightest doubt in your mind, you should resolve it, as we will seek to argue in due course, in favor of the applicant. The third matter to which I wish to refer by way of a preliminary introduction is this. Before we turn to the facts upon which this particular application is grounded, it is important that we should know the basis upon which your ladyship is viewing it. That is to say, there should be a statement of the facts as you understand them to be, right at the outset now, so that we are aware of the basis upon which your ladyship is seeking to address the issues that we have raised by way of the affidavits in this case. We rely in making that submission on the two cases of Hilo and the Secretary of State for the Home Department. Can I turn your ladyship to that? It should be the third case in the bundle.
1 minute.
Yes.
Say her third case. It's in my bundle at 21, but Hilo is the case. Hilo and the Secretary of State for the Home Department, the authority we rely on is House of Lords case, at 2008 One Weekly Law Reports.
Oh, I have to find that because that's, oh, I see it.
It should be
21.
It should be tab 21, I think.
Yes, I have it. Thank you.
We'll return to this case in due course, but can I take you first of all, please, in making good the submission that we've just made, that your ladyship should turn, if you would, please, to paragraph 39. Please, paragraph 39 of the judgment. And just to give it some background, this is a case in which the applicant was a Palestinian asylum seeker, and the judge was said to be a member of the Jewish Lawyers Association, which had made a number of public pronouncements that were regarded as being anti-Palestinian. I think that's sufficient for the purposes of identifying the background, but paragraph 39 is instructive in our respectful submission as to the approach that the court should take. What was said there by Lord Mance was this: the basic legal test applicable is not in issue, as here. The question is whether a fair-minded and informed observer, having considered the relevant facts, would conclude that there existed a real possibility that the judge was biased by reason of this case of her membership of the association. The question is one of law, to be answered in the light of the relevant facts, which may include a statement from the judge as to what he or she knew at the time. Although the court is not necessarily bound to accept any such statement at face value, there can be no question of cross-examining the judge on it, and no attention will be paid to any statement by the judge as to the impact of any knowledge on his or her mind. That makes clear in our submission that it is both desirable and important that we should have some statement of the facts as your ladyship regards it, bearing in mind the nature of the submissions as outlined and identified in the affidavits. Can I, in reinforcing that submission, invite you to go to the Resolution Chemicals case, which is at tab 5 in your ladyship's bundle, and paragraph 42, which takes up the issue.
Yes.
Paragraph 40, no, the Resolution Chemicals case is one which it involved a patent where the judge had been a student when his research supervisor from his university some years before had been, they'd had that relationship. One was the research assistant or supervisor, and the other was the judge whilst at university. That research supervisor was now to be a witness in the case. And an attempt was made to, as it were, use some other evidence rather than that. But for these purposes, I think is sufficient. But what is useful is what's set out at paragraph 42, where
42? Sorry, paragraph 42?
Paragraph 42. So Terence Atherton, in his judgment, saying this, as the judge, oh, sorry, I'll wait until your ladyship turns it up.
Yes.
As the judge noted, Lord Justice Patton said in the LB Children case, as quoted there, that judge faced with a recusal application on the ground of apparent bias, as here, quotes, explain in sufficient detail the scale and content of the professional and other relationship which is challenged on the application. it is plainly consistent with the policy underlying Article 6.1 of the Convention, that's the Human Rights Convention, and common law principles that on such an application, the judge should provide to the parties relevant information. Such information, however, should not go beyond what is strictly necessary for a fair adjudication of the recusal application. And he observed that in that case, he thought the judge had gone too far. But the point here is simply this, that it is both right and proper that your ladyship should, in the light of the affidavits that have been provided to the court, to set out in brief form what it is that your ladyship will say about that factual background, so that we are able to address that for the purposes of the submissions made before your ladyship today. Those are the three introductory matters that I wish to bring to your ladyship's attention.
Lynch, when you say set out the facts, these are facts that will be set out in a judgment, or these are facts that should be set out for you to then address me further?
Yes, in our respectful submission, what your ladyship should be doing is to, and should have done, is to provide a factual matrix against the background of the affidavits that have been provided. That is to say, we should have in advance some factual material. It may be no more than a couple of lines. It may be a paragraph. It may be, it's a matter for your ladyship to determine what facts you wish to place before us all, so that we can properly address the issues that arise in this case.
I see.
And it is, in our submission, it would be unfair on the defendant to only learn of that in your judgment, that we should have it in advance for those purposes. And indeed, it's something I averred to, I think, in the written submissions that we made back in May of this year. So in our submission, those are the three principal matters that your ladyship should consider. First of all, the informal approach that was identified in El Faraji. Secondly, the precautionary approach, that is to say, we're exercising your discretion to pass this to some other judge to deal with if you feel unable to recuse yourself. And thirdly, to have a factual account of what you say in relation to the those facts that have been identified in the affidavit. So those three issues we submit are matters of importance that your ladyship should address, and we should then proceed on the back of your view about those three, what we would regard as important introductory features. And of course, I'm entirely in your ladyship's hand as to how you wish to address that.
Yes.
We therefore would wish to turn to what we say are the facts as we understand them to be.
Yes.
So that your ladyship and all of my learned friends will have, hopefully, the way in which we put it in relation to the facts relied upon for your ladyship to recuse yourself.
Yes.
There are two principal strands, as you'll appreciate, to our submissions. Firstly, that the relationship between you and your father and the defendant. And secondly, the relationship between you and Mr. Mussenden and the defendant. Now, it's obvious that we don't wish to name anybody that can avoid being named, and I won't do that for the purposes of the submissions that we make in relation to the facts. There are two affidavits that are before your ladyship, one from Dr. Brown and one from Dr. Warner. It's clear from those affidavits that about 25 years ago, so some considerable time, 4 doctors, Doctors Brown, Warner, RW, and Subert, sought to establish a specialist medical practice. They engaged with a Dr. W.M., who was an ear, nose and throat specialist, and a vascular surgeon, a Dr. J.B. Property was sought to be purchased, or in the throes of having been purchased, was to be established for the purposes of running such a specialist practice. But what happened was that Dr. Subir sought to go behind the backs of the 3 other doctors with whom he was partnered in this enterprise, seeking, as it were, to try and establish the practice on his own, with the Dr. W.M., who was the ear, nose and throat specialist, and probably also with the vascular surgeon, J.B. That obviously caused some considerable disquiet amongst his both friends and work colleagues. There was, as a result, considerable loss occasioned as a result of his actions. And can I turn, please, in order...
I was going to ask Mr. Lynch, you're looking at the affidavit evidence of Dr. Brown?
Can I ask you, first of all, to go to the affidavit evidence of Dr. Warner?
Okay, I have that in front of me also. Thank you.
Thank you. Just give me one moment so that I might turn it up. I don't propose to read it out, all of it, of course. Can I take you to 3 what we regard as important passages? Paragraph 6.
Yes.
We regarded this enterprise as good for Bermuda and good for us as doctors. It quickly became apparent that Dr. Henry Subir was undermining our collective effort by apparently separately negotiating with the ear, nose and throat doctor. We were shocked and surprised by this turn of events, as he had completely undermined our negotiating position. The entire enterprise collapsed following considerable acrimony, especially as it cost us circa $30,000 each. I pause to say that that's probably nearer to $50,000 by today's standards. To this day, I do not understand why Dr. Subir would have behaved in that way. Paragraph 7. The relationship between the other partners and Dr. Henry Subir became very strained, to the point where on one occasion I had to step between Doctors R.W. and Dr. Subir to prevent a physical altercation between the two. Happily, I did. He stopped a fight. And then lastly, at paragraph 10, I frankly find it hard to speak to him whenever our paths cross. We all felt such a very deep sense of betrayal when he undermined our collective efforts to hold a new specialist practice, to build, a new specialist practice here in Bermuda. These events are of some antiquity, yet that we all remain so resentful about what he did speaks volumes about the depth of feeling and the sense of permanency in the breakdown of any relationship we had. Can I take your ladyship next to the affidavit of Dr. Brown? Again, I don't propose to read
Yes,
out.
I have it in front of me.
Can I take your attention first of all to paragraph 6? We, the doctors, experienced a real sense of betrayal by Dr. Subir, whom we had trusted, but who had sought to undermine our joint venture. A great deal of bitterness surrounded the collapse of this plan. And to this day, the relationships between all of us individually and Dr. Subir remain strained. In fact, one doctor, Dr. Warner, has not spoken to him since. Paragraph 7. Since the collapse of our business plans, to the best of my knowledge, Dr. Subir has not referred to any patients. Dr. Subir has not referred any of his patients to either of my clinics, that is the BHCS and the Brown Darrell Clinic for any scanning services. And that was so even when the hospital has been closed to referrals and I had the only alternative facility on the island. The sense of animosity lingers to the point that the judge's father and I have not had an amicable social or business relationship since. And that deals in part with the submissions that we make as to the factual background that we seek to invite your ladyship to recuse yourself, because, and I make it clear that that sense of betrayal and loss between the two, albeit many, many years ago now, and I accept entirely that it is a long time ago, it is in fact the very fact that it's so long ago and still obviously so seething as between those who are on this side of the divide and Dr. Sabir. And of course, I have absolutely no idea what position your father would take in respect to this matter. And it would be wrong of me to even begin to suggest, as has been suggested by Miss Christopher, that in some way there's no evidence to contradict it. It has been open to anybody, frankly, to contradict it. The affidavits have been before this court and served on everyone for some considerable time. No evidence has been adduced to in any way undermine that which has been said by these two particular doctors. And in our submission, it would be quite improper for us to approach Dr. Sabir in order to take any kind of statement from him. What we are entitled to do is to identify what we say are the features that lead to a sense of betrayal by a particular doctor to others, which has lingered for many years. And that, we submit, must inevitably have affected, on its face, and in the absence of anything to the contrary, must have affected the relationship that he has had with them and has expressed to you. It might not be the case if, for example, the defendant in this case had not become the premier. It might not be the case if the defendant in this case was not a well-known public figure. But the very fact that he is a public figure, that he has been the Premier of Bermuda, against that background and against what has been a lengthy inquiry with all the attendant publicity that it has generated, it is inconceivable in our submission, inconceivable, that someone who must have had a view about him was not going to express it to his daughter. And we find that on its face.
Sorry, it's inconceivable that someone had a view about
Dr. Brown
would not express,
and that he would not have expressed his view of Dr. Brown to his daughter.
That Dr. Sabir would not have expressed his view to me.
Yes.
I see. And you say that's inconceivable.
Yeah, I do. I say it is on its face, in the absence of anything to contradict that, it is inconceivable that a father and daughter would not have discussed against the background of the publicity that was attendant upon Dr. Brown over the years, and given the relationship between the two all those years ago, that he would not have expressed his own view about what he thought of Dr. Brown, whether he was trustworthy, whether he was honest, whether he thought he was in some other capacity, someone not to be relied upon. All of those sorts of issues are the sort of thing that transpires between families. The idea that you don't sit around a dinner table and say, oh, well, you see that story this week in the newspaper about Dr. Brown, and you don't express a view, you're all silent about it. I find that difficult to believe, but it's not a matter for me as to whether I think it's difficult to believe. What I'm suggesting is that the fair-minded, informed observer, considering the relevant facts, might think that there was a real possibility that that is what had happened. And this is a case. This is a case where the credibility of Dr. Brown is cardinal. It's at the forefront of the issues in the trial. And his credibility, that being the issue, it seems to us that it is against that background and on its face that family members would not have discussed their views about a particular individual. I imagine that virtually every Bermudian family has done so, but they're not going to be sitting in judgment. That serves as the...
sorry, Mr. Lynch, let me just ask you while you're on that point. Do you say that the evidence points to an inference that Dr. Sabir would have had an adverse view of Dr. Brown?
Yes.
I see.
Why else would somebody do what he did?
Yes, thank you.
You'll appreciate that it is not simply that which we seek to advance by way of factual background as to why you should recuse yourself, but that there is a second strand, which, can I say straight away, may not on its face, if that were the only basis upon which we were making the submission, would be one which might lead to recusal. But it does in our submission add weight, considerable weight, to that which we have already expressed. And that is the relationship between you and Mr. Mussenden, who is now a puisne judge in Bermuda. Your ladyship will know that you and Mr. Mussenden were in business together and have been together in professional capacity in a variety of ways over a number of years. Our submission is that on its face, once again, there is a relationship between you and someone whom we submit may have harbored some animosity towards Dr. Brown. And that if that were so, it is almost inevitable once again, and I use the word again, inconceivable, that friends in the legal profession would not discuss someone, particularly someone as Dr. Brown, who is in the forefront of the publicity machine over the years.
Can you,
exactly the same way.
Mr. Lynch, can you take me to the evidence from which I can draw an inference that there would be feelings of animosity from Mr. Mussenden towards Dr. Brown?
Well, let me be clear. I cannot, and none of these cases for recusal can impute with evidence a feeling of animosity.
No,
what we can do is to draw upon what evidence there is and invite the court to infer that that must be so, or may be so. The threshold in our submission, as we'll turn to in due course, is a relatively low one. And so we invite your ladyship to consider that. And I turn to Dr. Brown's affidavit.
Yes.
You'll see from paragraph 8, he says this: additionally, and also giving rise to concern over the appearance of bias, there is the relationship between the learned judge and the former DPP, Larry Mussenden, now a puisne judge. It is a widely held belief in Bermuda by myself and others that the two are very close friends, having been in a partnership together in their former legal practice. Mr. Mussenden, as he then was deliberately not reappointed as the Attorney General when I was elected to the office of Premier. I genuinely believe that there has been a degree of animosity between us ever since. The learned judge will be aware that there is an extant constitutional claim in which criticism is made of the former DPP and the manner in which he conducted his role as DPP in relation to his independence in the decision-making process. Your ladyship will understand that in that constitutional allegations set out in the pleadings, For 5 years, Mr. Mussenden was involved in the continuing investigation of the defendant in his role as the DPP, advising on what is characterized as an acronym as JIPT, a Joint Investigation Prosecuting Team Panel, set up solely for the purpose of investigating and prosecuting the defendant. It took nearly 10 years in total and involved, as we now know, the illegal activity of some of those involved on the part of the police. He is the subject of criticism and allegations of a breach of the Constitution in a separate action brought by the defendant and represented by Mr. Delroy Duncan. There is no love lost between Mr. Mussenden and the defendant, who refused to approve his reappointment as the Attorney General when he became Premier. Criticism is made of those observations by Miss Christopher in her submissions, saying that, well, that never happens in any event. That the position is that Attorney Generals are very often reappointed once a new Premier is elected, and that may or may not be the case. What is clear, though, is this, isn't it? Is that when Dr. Brown did become Premier, the party that was in power was already the PLP. It's not as though there was a change of party which would occasion the necessity for a change of Attorney General. And it's worth observing that when one looks at the indictment in this case, that a period of that indictment is covered over the period in which Mr. Mussenden was the Attorney General. So Mr. Mussenden was Attorney General, covering a period which now criticism is being made of Dr. Brown and his involvement with the Leahy Clinic over the very years that Mr. Mussenden was the Attorney General. We submit that the relationship between you and Mr. Mussenden must inevitably have led to discussion and views being expressed by Mr. Mussenden to you about what he thought of the propriety, the honesty, the integrity of Dr. Brown. It is, in our submission again, inconceivable that lawyers practicing together and who've known each other for many years and might be described or generally viewed as friends would not discuss something as fundamental as that, as between each other at a time when Dr. Brown would have been in the forefront of publicity. It is the very sort of thing that is likely to stimulate conversation over dinner or a drink or in the office over a cup of coffee or at the water.
Sorry, the fact that he had not been reappointed as the Attorney General?
No, but that there is animosity between the two, that there is a belief of animosity between the two, and that not being reappointed as Attorney General is just but one feature of that. I seek to identify, in the way which I have, the other features, which are that Mr. Mussenden himself was the Attorney General during a period of time, which it is now said Dr. Brown had in some way been committing corruption.
The factual limb that you referred to as Mr. Mussenden, who would have been carrying out his role as a DPP, should I not take notice that at that time I was the registrar of the Supreme Court and or a sitting judge?
Of course you should. Why shouldn't you?
Okay. Thank you.
Of course you should. I want to make it clear that I'm not suggesting that there comes a particular point in time at which Mr. Mussenden might be saying, oh, well, I better have a chat with Judge Williams, or I better have a chat with the registrar at the time. That's not how it works. We're talking about lawyers practicing together who will express a view about individuals, particularly those individuals in the public eye, in the public domain. And it is almost inevitable that people do that. I don't know what your office is like, and I've invited your ladyship to make a factual statement about the position, that is a entirely view.
I'm trying to be clear on the inferences that you're inviting me to draw, Mr.
Yes.
Lynch. I'm not expressing a view at all.
I'm not inviting your ladyship to draw any inferences at all. What I'm doing is to invite your ladyship. No, what I'm doing is to invite your ladyship to say that the fair-minded, informed observer, considering these facts, would think there was a real possibility of bias.
Yes, and they are obviously based on the facts before me. So I just want to be clear where Mr. Mussenden is concerned. The factual basis that there could be an inference of animosity between Mr. Mussenden and Dr. Brown during the time that Mr. Mussenden and I were partners in law firm Mussenden Subert. The background at that stage would have been in relation to him not having been reappointed as the Attorney General. Mr. Mussenden would not have been the DPP at that point, and so all of the evidence that refers to his role as a DPP would have post-dated my partnership with him at Mussenden Subert. I just want to understand what you are suggesting would appear to be biased from that stage.
I'm not suggesting that it takes place at that particular point in time at all. I am saying that the relationship between you and Mr. Mussenden was one of friendship and partnership, and that you had both at the time various appointments in various legal capacities, that your relationship is one which gives rise to a genuine concern that expressed views may have been exchanged between the two of you over that period of time. It's not confined to simply because he wasn't appointed as the Attorney General. That is a feature that has been identified as one factor. And I'm suggesting to you that that relationship between the two of you is such that he will, or it is, as I have used the word before, inconceivable that he would not have expressed a view about someone in the public domain against whom there has been a degree of animosity between the two. And that animosity is predicated not simply, as I say, on the fact of he was not appointed as the Attorney General, but because it is clear that he was the Attorney General over a period of time, a period of 5 years or so, when the allegations that are now founding part of the counts in the indictment are present. And so his view of the defendant is something that may and is likely to have been expressed to you over a period of time.
I see. His view of Dr. Brown, or his view of the merits of the investigation?
Of Dr. Brown, his view of Dr. Brown. That is the factual background that we seek to rely upon in order to make the submissions that we do. And what I'd like to do now is to turn, if I may, to what we say is the appropriate test and how your ladyship should approach it. Can I invite you to return to the Resolution Chemicals case?
Yes, Mike, I just have to reload my computer 1 minute.
Yes.
Yes.
So our concern is that the court, through its association with your father and good friend, has been influenced in an adverse way towards the defendant, or it would create in the mind, as I've said already, the fair-minded, informed observer, considering those relevant facts, would think it a real possibility of unconscious bias. And can I take you in looking at the test to Resolution Chemicals at paragraph 33. This is the patent case where the witness had previously been involved as an advocate. Can I take you to paragraph 35, please? Forgive me, paragraph 35, under the heading discussion. Because this case, a case determined in 2014, having reviewed many of the authorities that we are familiar with and others have relied upon, makes what are identified as the 5 principal points, and it's useful to identify them because it will save us having to look at all the authorities that support them. But can I, in doing so, it's Sir Terence Atherton who makes the observations in his discussion. And he says this: the following principles relevant to the application are clear. First, the test of apparent bias, that is where we are, is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased, and he cites there Porter and McGill. There is no difference between the common law test of bias and the requirements of an independent and impartial tribunal under Article 6.1 of the Convention for the Protection of Human Rights and Fundamental Freedoms, and that we would submit is the same as in the Constitution in Bermuda. And he cites there the case of Lowell, to which we'll refer in due course. Secondly, second principle, underlying both Article 6 of the Convention and the common law principles is the fundamental consideration that justice should not only be done, but should manifestly and undoubtedly be seen to be done. And he quotes there the case of Sussex justices. Third principle, the fair-minded and informed observer is not unduly sensitive or suspicious, but neither is he or she complacent. See Helo, again, to which we refer. And fourth principle, the facts are context critical. Each case turns on an intense focus on the essential facts of the case. And he quotes there the case of Man of War Station Limited and Auckland City Council. And then fifthly, if the fair-minded and informed observer would conclude that there was a real possibility that the tribunal will be biased, the judge is automatically disqualified from hearing the case. The decision to recuse in those circumstances is not a discretionary case management decision reached by weighing various relevant factors in the balance. Considerations of inconvenience, cost, and delay are irrelevant. And he quotes there AWG Group. He goes on at paragraph 36 to say this: in addition to those well-established points of principle, I would add the following observation. The test is a real possibility of bias, whether subconscious or otherwise. Lundbeck's skeleton argument describes that test as a necessarily low threshold. While the test is certainly less rigorous than one of probability, it is a test which is founded on reality. The test is not one of any possibility, but one of a real possibility of bias. And indeed, that Lundbeck's skeleton argument borrows heavily from Lord Staines's judgment in the Lowell case, to which I will return shortly. In our submission, that, coupled with the precautionary principle, that is to say, a low threshold, one which is designed to provide a low hurdle over which the court should proceed, that combined with the precautionary principle that we're doing this at the outset of the trial, we're not in the middle of a case, in our submission, is one which should persuade the court that it is right and proper to recuse itself. Can I take you over the page, please, to paragraph 39, where the precautionary principle is identified again by Sir Terence Atherton. The precautionary principle is a sensible one in view of the obvious practical complications if there is an appeal from a refusal to recuse, or if there is a challenge made on the basis of apparent or actual bias at the end of the case. The overriding objective that justice should be seen to be done, and the need to maintain confidence of society in general and of the parties in particular in the administration of justice, also promote a disposition of a judge to accede to a recusal application when it is made by a party's legal advisors. And then in the next paragraph, the last 4 lines, please. The increasing pressure on limited judicial resources aptly reflected in the present case on the shortage of judges suited to try this complex patent action may mean that the easy option of voluntary recusal, irrespective of the strict application of the legal test, may from time to time have limited scope. Our submission is clear. We understand, and it is obvious, that there are a limited number of judges available in Bermuda to try these sorts of cases. That should not, in our submission, inhibit your ladyship from coming to the right conclusion, which is that you should recuse yourself. Can I take you next, please, to paragraph 16 of our skeleton argument, in which we set out there what is said in Lowell, and I perhaps need not refer you strictly to the case at this stage. I can give you the reference. When dealing with application...
One minute. Were you now?
I'm paragraph 16 of the skeleton argument.
Okay. Yes. Yes.
This is a case, just so that your ladyship has the background to it, this is a case which involved a representative at the Employment Appeal Tribunal. It was one of the wingmen, if I can put it like that, at the tribunal, who was also a representative, had represented one of the applicants. The point about the case was that it was initially rejected, that there was any recusal, all the way up till it got to the House of Lords, where the application was allowed. The point about the case, though, and what one takes away from it is this, is that the threshold for recusal is only a real possibility of unconscious bias. It is described in the judgment as a necessarily low threshold. And we do emphasize that because it is important that your ladyship should not, as it were, elevate this to the point where there is the kind of evidence that one would normally have in a trial where there are issues to be determined by the two sides. That is never going to be the position in a recusal application unless there's some documentary evidence to demonstrate that the judge has a pecuniary interest in the outcome or something of that kind. That is never going to be the position in cases which involve, as this one does, what we describe as the necessity to identify only that there is a real possibility of unconscious bias. And so it is important in our submission that against that background, it is recognized that the threshold is a low one. Can I take your ladyship next, please, to the authority of Miller and Dixon, which your ladyship should have at tab 7.
Yes.
When I turn it up. This is a case in Scotland where a number of temporary sheriffs were awarded placements as judges, temporary judges, and it determined a significant number of criminal trials.
All right, one moment, please. Oh, I see. Yes, thank you. I have it.
Okay. What was particularly significant in that case is that if the court were to rule that there was a breach of the article of impartiality, it would have a very significant effect on a large number of trials that have been taking place under this temporary sheriff rule. And indeed, they did in the Court of Appeal, in the Privy Council, as it was from Scotland, in the Privy Council, determined that it was a breach of the rule that it should be impartial. And can I take you in dealing with that to paragraph? Yes, if we start at paragraph on page 1621, Lord Bingham.
Yes.
Between letters F and G, what is little 6?
Yes.
And he quotes there, he's quoting Lord Reed with a positive assertion. Before concluding this part of my opinion, I wish to make plain that I am not suggesting that any temporary sheriff has ever allowed his judicial conduct to be influenced by any consideration of how he might best advance his prospects of obtaining renewal of his appointment. And the sheriffs, being temporary, might have been regarded as people who wanted to either take the job permanently or to be renewed in their temporary appointments. Nor am I suggesting that any official or minister has ever sought to interfere with the judicial conduct of a temporary sheriff, or would ever be likely to do so. There is, however, no objective guarantee that something of that kind could never happen, and that is why these appeals must succeed. What he's saying there is that there's no way you can know what Dr. Subert or Mr. Mussenden may or may not have said, or what they might think, because we don't have that evidence and we never will. What we can say is that what the fair-minded, informed observer might think in considering those facts is that there was a real possibility. No objective guarantee that something of that kind could never happen. And can I take you next, please, to in the judgment to Lord Hope of Craighead at page 1639, paragraph 63.
Yes.
Can I take you to paragraph 63? Lord Hope was there dealing with a submission being made, and he says this, that in my opinion, this argument overlooks the fundamental importance of the convention right to an independent and impartial tribunal. These two concepts are closely linked, and the appearance of independence and impartiality is just as important as the question of whether these qualities exist in fact. Can I hope, without appearing to be discourteous in any way, emphasize that particular line? The appearance of independence and impartiality is just as important as the question of whether these qualities exist in fact. Justice must not only be done, it must be seen to be done. The function of the convention right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires this matter to be viewed objectively. The aim is to exclude any legitimate doubt as to the tribunal's independence or impartiality. And he quotes there a number of authorities and then says, the question of impartiality, actual or perceived, has to be judged from the very moment when the judge or tribunal becomes first seized of the case. At paragraph 65, can I take you next to there? The principle of the common law on which these cases depend is the need to preserve public confidence in the administration of justice. It is no answer for the judge to say that he is in fact impartial, that he abided by his judicial oath, and there was a fair trial. The administration of justice must be preserved from any suspicion. I repeat again, the administration of justice must be preserved from any suspicion that a judge lacks independence or that he is not impartial. If there are grounds which would be sufficient to create in the mind of the reasonable man a doubt about the judge's impartiality, the inevitable result is that the judge is disqualified from taking any further part in the case. No further investigation is necessary. Lastly, to move ahead to Lord Clyde in that judgment at page 1647, paragraph D.
Sorry, 1647.
Paragraph D. Lord Clyde's judgment. And he says this at D: the appearance that justice is being done is as important as the actual doing of justice. The independence of the judiciary is not an empty principle which can be forgotten simply because one thinks that a correct conclusion has been reached. Rightly or wrongly, there is always room for an uneasy fear that there might have been some improper influence affecting the mind of the judge where he lacks independence. The principle is far too important to allow it to be passed over in the way in which the respondent suggested. In our submission, what we have here is an expression of the low threshold that has to be overcome. In that case, hundreds of decisions of the sheriffs were overturned, not because anyone thought that they'd got the law wrong or that the court's finding was in any way inaccurate, that these defendants were or were not guilty. But hundreds of them were set aside because of the necessity to ensure that there was no appearance of bias. And as I say, the threshold as expressed there by the Privy Council and the judges in that case is that the threshold is a low one. And I emphasize it because literally in the last words of Lord Clyde, if you turn over the page at paragraph 85, the last 5 lines, at letter C, between B and C.
Yes.
The principle of independence and impartiality of the tribunal, particularly in criminal cases, is too precious to be put at any risk. I should be sorry if in a case like the present one, we were to allow any derogation from that principle, even if the consequences of holding to it involve the invalidation of convictions which from every other angle were safe and unimpeachable. And that really just echoes that which I've submitted to your ladyship about the importance of it and the low threshold that has to be overcome. So what are the features or the factors that are important in determining whether the threshold has been met? And can I take you to our skeleton argument at paragraph 20, please? And turn, if I may, to the case of Porter and McGill, which some reliance is placed on by Miss Christopher.
Am I just going to look at what you've quoted in your skeleton argument?
I think actually it's probably better if we go to the authority, because she has relied on almost the same passage, but as it asked for a different emphasis. But can I just take you to a little more? Give me one moment myself to find it.
I have the case. Where am I?
Yes, just give me one moment. I've got to bring mine up on the screen as well.
Yes, thank you.
So would you go, please, first of all, to paragraph 25, I believe it is.
25?
Yes. I've got the wrong copy of it.
I don't see paragraph.
It's on page 480.
480?
It's on page 480. Yeah, the paragraphs are not great, I'm afraid, in that particular version of the judgment. But I've got the wrong copy of it up. If you just give me one moment. Here we are.
Okay, I actually do see paragraph numbers here on 480. Which paragraph are we looking at?
So paragraph 25.
On page 480?
480, paragraph 25.
The first paragraph number is 53.
Right. I don't know which version of, are you looking?
2002 2AC.
No, I'm in the Queen's Bench 2000.
These are the authorities that you, I'm still looking at what you filed.
Yeah, that's what I found. Well, I don't wish to dwell unnecessarily and try to find the exact quotation. Can you just give me one moment? Is your ladyship?
I'm sorry to interject, but I think the court may be looking at Porter and McGill, whereas I think my learned friend is referring to Lock bail.
Yes.
That's correct. I thought you were asking for me to look at Porter and McGill.
No. Did I say Porter and McGill?
I thought that you did, but
I may have done, and it's my fault. So forgive me, and I'm grateful to Mr. Richards. It's Locker bail that I wish to refer to.
Sorry, what passage is that?
It's a page 480 of Locker bail, and it's at paragraph 25, which is right near the top, at letter B.
Thank you.
yes, I have it. Thank you.
This is a case which involves, in fact, 5 separate cases entirely. They were all unconnected, and all the court were dealing with was the principles surrounding a recusal and then turning to each and every case. And that's perhaps why it's quite such a long case. But it perhaps doesn't particularly matter for these purposes to identify what the facts are in relation to each of those 5 different scenarios that were placed before the court. What is important are the matters of principle that are outlined at paragraph 25. And there, the court is saying, in essence, it would be dangerous and futile to attempt to define or list the factors which may or may not give rise to a real danger of bias. Everything will depend on the facts, which may include the nature of the issue to be decided. And then they exclude or identify a whole range of things which are exclusionary. They don't think could satisfy the test. We cannot, however, conceive of circumstances in which an objection could be soundly based on the religion, ethnic or national origin, gender, age, class, means of sexual orientation of the judge, nor any rate ordinarily would be objection to soundly based on the judge's social or educational service or employment background or history, nor any member of the judge's family or previous political associations or membership of social or sporting charitable bodies or Masonic associations or previous judicial decisions or extracurricular utterances. And then if you skip a few lines, it says, by contrast, a real danger of bias might well be thought to arise if there was personal friendship or animosity between the judge and any member of the public involved in the case, or if the judge were closely acquainted with any member of the public involved in the case, particularly if the credibility of that individual could be significant in the decision of the case. Now, I pause there because in our submission, that is precisely where we are. There is a real danger of bias as a result of the relationship we submit between you and your father and the defendant. It's one of animosity.
Sorry, so you're saying that puts me into which category? That I would have a personal friendship or animosity with any member of the public involved in the case, or if the judge is closely acquainted with any member of the public involved in the case?
Yes.
How do those facts?
Well, because I'm submitting that the relationship between your ladyship and your father is likely to have led you, albeit perhaps subconsciously, but is likely to have led you to have come to a view as to the particular individual that you're looking to try, who has, as part of his case, the issue of his credibility at the forefront of it. His credibility is that the central element of any trial that will take place against him. And your view as to his credibility, his honesty, his integrity is crucial to that. And in our submission, given that those are the facts, the fact that there is a relationship between you and someone with whom he has had a major fallout with, albeit those years ago, but one which has lingered to this day, is bound to have colored your view as to this particular individual. That's why we say it's important, because it goes directly to a view that you may have of his credibility, his honesty, his integrity, which is at the heart of the case.
Mr. Lynch, your submissions bear in mind that what we are looking at ultimately, if you look at the substantive hearing as a jury trial, and the role of the judge in a jury trial, how does that feature in your submissions in terms of your argument that I would take it, or there's an appearance that I would take an adverse view of the credibility of Dr. Brown?
Because you'll have to make decisions about the admissibility of evidence. You'll have to make decisions which may or may not impact on his credibility. There are decisions and directions to a jury in due course. All of these are factors which are a necessary element of the discretion that is vested in a judge in determining whether evidence should or should not be admitted. I mean, take, for example, application, is it section 93, where the manner in which evidence is obtained. So it seems to be that in a case where evidence is obtained in a particular way, or which is sought to be excluded as being unfair, those are factors where a question of the defendant's honesty and integrity are relevant in a decision that the court might have to make about the admissibility of evidence, as indeed in any part of a submission during the course of a trial where there are issues that arise that affect a discretion being exercised by a judge, quite apart from, as I say, the directions that you will give to a jury at the conclusion.
Thank you.
The only other passages that perhaps I ought to draw your attention to are between F and G on the same page.
Yeah.
If for any other reason there were real grounds for doubting the ability of the judge to ignore extraneous considerations, prejudices and predilections, and bring an objective judgment to bear on the issues before him. Skip 3 lines, please. In most cases, we think the answer one way or the other will be obvious, but if in any case there is a real ground for doubt, that doubt should be resolved in favor of recusal. We repeat, every application must be decided on the facts and circumstances of the individual case. The greater the passage of time between the event relied upon as showing a danger of bias and the case in which the objection is raised, the weaker, other things being equal, the objection will be. We bring that to your attention because right we should. But in our submission here, what is clear is that the passage of time, if anything, has actually sought to make it, to reinforce the relationship between these doctors, in particular my client and Dr. Subert, because even after all this time, what is evident from the affidavits is that there is a considerable degree of animosity that lingers after all this period of time. Can I take you, I have not intended to rely on Athene Holdings, it's just in a footnote in our skeleton argument, but it has been identified by both Ms. Christopher and Mr. Deal, and it might be useful to just at this juncture turn that case up. Can I ask you to do so, please?
Yes, I have it.
Just give you one moment for me to do the same. What's clear is that the Chief Justice there was applying exactly the same principles that we've been identifying.
Okay, so let me just observe quickly. I have it from page 3 in front of me. Obviously, I can access the fuller judgment after the hearing, but is there any reason why I need to see the first 2 pages?
Is there any reason why you need to see more than the first 2 pages or just the first 2 pages?
No, I have page 3 to the end of the judgment. For some reason, the hard copy in front of me has omitted the first 2 pages.
I don't think that matters very much. I was simply going to draw your attention to paragraph 53, which perhaps the simple point I was going to make was that the case is very much confined to its own facts, and what perhaps gives the reality to what was happening in that case is what's set out by the Chief Justice in the 4 lines that make up paragraph 53, where he says this: the objection based on apparent bias was taken immediately after I had delivered my ruling of the 14th of January, dismissing the first and second defendant's application to set aside the order, giving leave to serve the proceedings on them outside the jurisdiction. What the Chief Justice did, if I may respectfully say so, is that he recognized that this was a ploy by Mr. Potts, Queen's Counsel, to try and get the court to revisit, by having a different judge, the issues that have been raised. And of course, that is to be, if that's what it was, it is to be deprecated. What is clear is that there have been a number of hearings before this judge in relation to the case, and no objection had been taken at all. And it was only when an adverse finding was made that it was necessary, in the mind of those whom Mr. Potts was representing, to seek to have the judgment set aside by virtue of the fact that the judge should recuse himself, and then no doubt make an application that the argument should be heard all over again in front of somebody else. So for what that's worth, we don't rely on that particular case. No doubt others will point to paragraphs that they might regard as important, but we don't. Can I refer you next, please, to the case of Gillies and the Secretary of State for Work and Pensions, where Lord Hope makes a number of observations at paragraph 22. The case is Gillies.
Sorry, which case is this?
It's Gillies.
Yes, I see it. Thank you.
Just give me a moment while I turn. Yes, it's paragraph 22. Lord Hope of Craig's Head. Would you just give me one moment? I can try and find my hard copy of it where I've made a number of notes. Yes, paragraph 22 of my system. I'm sorry, I've lost my place for a moment. Would you just bear with me for one moment? Yes, forgive me. It's paragraph 17 of the judgment, not 22. I thought I got the wrong marking. Paragraph 17, under the heading discussion. The critical issue is whether the fair-minded and informed observer would conclude, having considered the facts, that there was a real possibility that Dr. Armstrong would not evaluate reports by other doctors who had acted as the MPs objectively and impartially against the other evidence. What had happened in the case was Dr. Armstrong had been a witness, and he was being dropped by one of the parties in favor of having other evidence being called in his place. And that was objected to. And the fair-minded and informed observer can be assumed to have access to all the facts that are capable of being known by members of the public, generally, bearing in mind that it is the appearance that these facts give rise to that matters, not what is in the mind of the particular judge or tribunal member who is under scrutiny. I pause there because what I'm saying is that, as I indicated earlier, Dr. Brown is in the public domain. He was the premier of the country. That necessarily attracts public opinion, and judges are no different to ordinary members of the public in expressing their views amongst their friends and family. And in our submission, that what that does is the fair-minded and informed observer can be assumed to have access to all the facts that are capable of being known by members of the public generally, bearing in mind that it is the appearance of these facts that give rise to the matters, not what is in the mind of the particular judge or tribunal member who is under scrutiny. So how does it look to the public when they say, they see a judge here, a judge whose father had at best a poor relationship with those that he worked with all those years ago, and who those in other doctors regarded him as having backstabbed them. That's how they regard it. How does the public view that albeit all these years later, with all the other factors that are around, that they would not have a view that the judge, who is the daughter of that particular doctor, would not have been influenced in some way by what that doctor may or may not have said over the years, subliminally, in the course of comment being made. And it is our submission that's why that passage is of particular importance. Can I turn to what we say, the informed observer? What are the factors that the informed observer would wish to take into account? And can I invite your ladyship to turn to paragraph 23? Before I do so, can I ask if you're planning to have a mid-morning break?
Invite me to. I'm happy to do so. Is this a good
Well,
point?
I could make myself a little more comfortable if I had 5 minutes.
Okay. I will actually suggest a 10-minute break. It's now 1:45. We can come back at 5 to 12 if that is convenient to all. Yes?
Thank you very much.
Okay, thank you.
Hello? Hi.
Jerome, you're
Mr. Lynch, we can hear you, so you may want to
I
mute.
better turn off then.
Yes, you may want to mute your microphone.
Thank you. Thank you, my lady. I'm ready whenever you are.
Yes, thank you.
Can I take you to our paragraph? Lost it already. In the skeleton argument at paragraph 23, please.
Yes.
Here's paragraph 23 of the skeleton.
Yes.
And the question really is, what are the factors that the fair-minded, informed observer would take into account in making up his mind? And you'll forgive me perhaps if I adumbrate them as set out in the argument. Firstly, that the oath taken by the judge pursuant to section 76 of the Constitution and the first schedule thereto, to do right to all manner of people after the laws and usages of Bermuda without fear or favour, affection or ill will. Secondly, that the judge's father, Dr. Henry Subert, is a physician who in 1996 had entered into advanced negotiations with the defendant and two other physicians about acquiring land and setting up a specialised clinic, incurring considerable costs, which were subsequently lost. Three, that the clinic project ended acrimoniously, such that, for example, to this very day, one of the physicians involved is not on speaking terms with Dr. Subert. Fourthly, that since the end of the clinic project to this day, it is believed that Dr. Subert has not referred any patients to either of the defendant's two clinics for any kind of diagnostic scanning, even when the only alternative diagnostic scanning facility at the King Edward Memorial Hospital has actually been closed. Fifthly, that the investigation into the prosecution of the defendant is one of the highest profile cases in Bermuda in recent history, and it has been the subject of intense media scrutiny and debate in society at large as well as in Parliament, which is bound to have engendered and did engender, we submit, discussion between the judge and her father and the DPP. And sixthly, that it is verily believed by the defendant and widely understood that the former Director of Public Prosecutions and the learned judge was and remained close friends, that the former DPP was not reaffirmed as the Attorney General when the defendant was appointed Premier of Bermuda, that the former DPP spent many years as an active participant in the prosecution team known as JIPT, the Joint Investigation and Prosecution Team, the subject of separate constitutional claim and breaches of constitutional guarantees, to which I've no doubt Mr. Delroy Duncan will speak. Seventh, that the fellow judge, and indeed one of the most experienced puisne judges on the island, has already and wisely recused herself as she regarded herself to be conflicted, because she says that, and I quote her, "My husband is a doctor and he and Dr. Brown have been colleagues and are friends. I do believe so that for that reason, I will not be, if this matter comes to trial, hearing that matter. And for that matter, although I do civil work, I certainly will not be dealing with the civil matter either. So there, one of your ladyship's fellow judges, who on a rather thinner ground has decided that she would not sit as a judge in this case because her husband happens to have some kind of collegiate relationship with the defendant. Now, the Privy Council considered the circumstances in which personal connections should play a part, and we refer to the case of Grant and the Teachers' Appeal Tribunal. Can I take you to paragraph 38 of that judgment, please? It's a case which, can I give the citation, 2006 UKPC 59, paragraph 38. Judgment given by Lord Carswell in the Privy Council. Right at the end of his judgment, this is a case in which the chairman of the board, which was responsible for the dismissal of the applicant, was known to the judge. Not apparently particularly well known, but known nonetheless. And what Lord Carswell said, paragraph 38, please. About halfway down that paragraph, it starts on the right-hand side, it is incumbent. Does your ladyship see that? Yes. It is incumbent on the judge to apply a careful and sensitive judgment to the question whether he is a close enough friend of the person encountered to make it undesirable for him to sit on the case. If he errs on the side of caution by too much, he may make it impracticable for him to carry out his judicial duties as effectively as he should. If, on the other hand, he is not ready enough to recuse himself, however unbiased and impartial his approach may in fact be, he will leave himself open to the suggestion of bias and damage the reputation of the judiciary for independence and impartiality. In this connection, it is relevant to take into account the issues in the proceedings. As Lord Bingham pointed out in the Locker Bail case, if the credibility of the judge's friend or acquaintance is an issue to be decided by him, he should be readier to recuse himself. If the judge and the chairman of the board had been close family friends who saw each other frequently, or if they had been regular golfing partners, it would no doubt have been much more likely that the real possibility of bias would have been thought to exist. And then over the page, last it is 4 lines down, the issues, the appeal did not involve any assessment of the veracity or credibility of the chairman's evidence, and the issues to be decided did not affect his personal position as distinct from that of the board which he chaired. In our submission, what that does is to provide some assistance in the approach that your ladyship should be taking to the issues in this case. In short, it follows that what is relevant is the relationship between you, your father, and the defendant, you, Mr. Mussenden, and the defendant, and the fact that the principal issue at stake in the criminal proceedings is the defendant's character and credibility. And it follows in our submission that the fair-minded and informed observer would take into account the likely effect on a defendant in criminal proceedings where it is possible or likely that the judge has been exposed to a negative view of his character held by those whom she has close to her. Here is, if I may put it in this way, what I regard as the acid test. Would we countenance Dr. Subert sitting on the jury, or indeed your ladyship sitting as the jury? Would we countenance that? And I rather suspect in the United Kingdom, judges could sit as jurors, and they do now regularly. If a judge had had the relationship that we submit you have had with your father and his relationship with this defendant, there is no question that you would have been asked to stand down as a juror. And all the more so in our respect for submission that you are the judge as proposed in this case. The nexus between you and those who are sufficiently close to you leave us, and we would submit the fair-minded, informed observer, having little doubt that there was a real possibility of bias.
Mr. Lynch, without wanting to interrupt you, I just want to have some sense as to how much longer you're likely to be.
I've got now 3 cases I want to refer you to, which are from the European Court, which give illustrations of the application of the principles. I can take them relatively shortly. They are set out.
I'm not rushing you. I just want to have a sense.
No, that's all right.
As to where we are. So, for example,
I spoke to Mr. Duncan during the break, and I had said to him I was confident I'd feel finished before lunch.
Okay, thank you.
So can I take you then, please, to some practical examples of the application of the principles? Now, I appreciate, of course, all examples are just examples. There is no principle to be drawn from these particular cases beyond the illustration of the application of the principles as we've identified them hitherto. But they do provide, we would submit, some guide to your ladyship in the way in which you might approach the principles and the facts in this case. And can I, in the first instance, take you to the case of Tokono, I'm not sure that I want to pronounce the next word, but I think it's something to do with professor, and Moldova. I'm going to call it the Moldova case, if you will permit me to do so. It's a case from 2007. It involved a dispute arising immediately after the breakup of the Soviet Union, when Moldova had become independent. Paragraph 36 probably sets out, in my skeleton, sets out that which your ladyship needs to know, purposes of the submission. The judge's son had been at a particular school and had been expelled. And that had happened about 3 years prior to the judge dealing with this case. And then what happened was that as I set out in paragraph 36, on this basis, the European judges found that the impartiality of the said judge was capable of appearing to be open to doubt, and that the applicant's fears in this respect can be considered objectively justified, because the judge had made it pretty clear that his son, having been to the school, was someone, and he held some grudge against the school, so that when the school was making an application in which he was determining, it was perceived that he would be prejudiced towards them. So there it was the judge's son who'd fallen out with the members of the applicants. The judge's son, not the judge's son had fallen out with them, and of course he harbored some animus. And here it's the judge's father who's fallen out with the defendant. And we submit that there is a clear analogy that can be drawn from the case. The court in Europe took the view that that was a case which the judge should have recused himself. So it's a clear proposition for the judge's negative relationship with the party by virtue of a close family member is grounds for recusal. 2 other cases then, please. Can I take you to the first Croatian case, the first name of which, because it has no vowels, I am completely incapable of pronouncing. SKRLJ against Croatia. a case from 2019, so quite recent.
Yes.
And your ladyship, can I take you to, please, paragraph 41. Have I got the right paragraph?
Yes.
Well, in short, the point is this, is that I think I need to go back a little, if I may. That if you go back to paragraph 38, please. The case involved a relatively minor traffic offence, but the judge declared that there was an animosity between him and the defendant's mother. And the defendant's mother happened to have been a judge, a brother judge, at the court at which this judge, the instant judge, was dealing with the son of that former judge. And the judge had now left the court, was no longer at the court.
I'm sorry, Mr. Lynch, you've confused me on the facts.
So there's the judge who was determining the relatively minor traffic issue had the son of another judge in front of him. And the other judge, the lady judge, had formerly worked at the same court centre, but no longer did. And there'd been a fallout between the two judges. And it was argued that there was that the judge should have recused himself from dealing with the son of the former judge.
I see. Okay.
And indeed, in that case, the judge on an earlier case had indeed recused himself, but on this particular case didn't, for reasons best known to himself. In that case, can I take you to, please, paragraph 38?
Yes.
The judge, who was a BLV, who conducted the minor offence proceedings against the applicant in a single judge formation, had only several days earlier agreed to be removed from another case against the applicant for the very same reason identified in his impartiality. So he'd already recused himself once and yet didn't on this occasion. But in any event, on a separate analysis of the case, at paragraph 41, please. In the court's view, this created a situation which was capable of raising legitimate doubts as to Judge BLV's impartiality, doubts which were not without objective justification, and was also of such a nature as to raise an issue under the subjective test. Even disclosing personal bias motivated by the judge's animosity towards the applicant's mother. The present situation differs in particular from that examined by the court in another Croatian case. They seem to have a lot of these in Croatia. On the 15th of January, when a judge who had refrained from sitting in a judicial formation as a precautionary measure without there being any particular reason to doubt his personal impartiality. The court reiterates that any judge in respect of whom there is a legitimate reason to fear a lack of partiality must withdraw. So in that case, where there had been a relationship between an animosity between the two judges, and then the son comes before the judge. No animosity on the face of it between the judge and the son of any kind. No suggestion of any such animosity. And yet the court here regarded it as proper that he should have recused himself in those circumstances. Lastly, can I turn to the second Croatian case of the Croatian Golf Federation and Croatia. And here they were parallel cases. This had arisen where there'd been an application to discharge the organization, the association, which was the Golf Golfing Federation, and they had sought to challenge that in the Constitutional Court. At the same time, there was a claim, a separate claim made for the repayment of fees as a member of the golfing club. So two separate cases. If the constitutional case failed, there would be no payment in the other case because there was no organization that could pay the debt. So they were wholly unconnected. But in that case, what had happened was, and can I take you to, please, what they said of it? And if you turn to page 100, to paragraph 122, I think we can skip that. That just deals with the facts. But the facts are set out at 122 to 124. But I think it's probably preferential for us to go to paragraph 127, which is under the heading, the court's assessment.
Yes. Where it starts, the court observes at the outset.
Yes, the court observes at the outset that the applicant association did not claim, and there is nothing to indicate any personal bias on the part of the judge, as here. It therefore considers that her personal impartiality is not at issue in the present case, as here. That consequently, its task is to assess whether the applicant association's doubts as to her impartiality may be regarded as objectively justified. In this connection, even appearances may be of certain importance, or in other words, justice must only be done, but it must be seen to be done. What is at stake is the confidence which the courts in a democratic society must inspire in the public. The judge sat on a 3-judge constitutional court panel deciding on the applicant's association's constitutional complaint against the administrative authority's decision to dissolve the association. If you turn over the page, we can skip the next few lines. Paragraph 131, 3 lines down. Yet a court cannot disregard the fact that once the Constitutional Court declared the applicant association's constitutional complaint inadmissible, the administrative authority's decision on dissolution became irreversible, and the debt of the golf club, whose president was the judge's husband, was definitely extinguished. The court considers that against that background, and having regard to the importance of appearances, the fact that the judge was a member of the Constitutional Court's panel, which decided the applicant association's constitutional complaint, was capable of raising legitimate doubts as to her impartiality. Accordingly, one should have withdrawn from sitting, but did not do so. The applicant association's fears as regards her impartiality can thus be held to have been objectively justified. And that is the second Croatian case to which we refer, and which gives some illustration of the application of the laws. Can I take you to paragraph 44 of our submissions, please, in the skeleton article? And you'll forgive me perhaps for reading this particular passage, because we regard it as important in summarizing what we say is the issues that your ladyship has to determine. It is in these circumstances that it is submitted that a fair-minded and informed observer would find that there was a real possibility that the judge is affected by an unconscious bias against the defendant on the singly most salient issue in the case, namely his character. The authorities clearly establish that the kind of relationship which exists between the judge's father and the defendant is such as to give rise to a situation of apparent bias. It is submitted that the circumstances which would cause the fair-minded and informed observer to conclude that there was an apparent bias and therefore a lack of impartiality, is the presence of animosity in the relationship and the clear possibility that this would affect the judge's opinion of the defendant's character. In our submission, as we've sought to indicate, the threshold is a low one. It is further submitted, the fair-minded and informed observer would consider it at best suspicious that if the judge did not recuse herself in circumstances where another judge recently recused herself on her own motion and on the basis of a less contentious relationship between her husband and the defendant, the fair-minded and informed observer would, in those circumstances, have grounds to query the impartiality of the Supreme Court bench as a whole in relation to this defendant. We said at the outset of these proceedings that this investigation into the defendant has been 10 years in the making. Prudence, if nothing else, suggests another judge should determine this matter. And if not, that your ladyship should recuse yourself now and leave it to another judge to deal with this case. If necessary, bringing a judge in from overseas to do so. It would not be the first time that that has happened. So lest it not be said that there is no other judge available to try it. And with respect, those are our submissions. Unless there's anything else I can assist you with, those are what we wish to do.
I do have a question for you, Mr. Lynch. There was an application that I dealt with a couple of years back where the applicant, I think they were judicial review proceedings, where the applicants included, I think, the Brown Darrell Clinic and Dr. Sandra Peretti, if I recall correctly.
That was a case brought by Dr. Reddy.
Yes. But
is that what you're talking about?
Yeah, but the Bermuda Health Service and...
Well, he works there.
Sorry?
He works there. It doesn't, it wasn't this defendant.
I appreciate the facts. Let me just put my question to you first.
Sure.
Sorry, I'm just trying to see if I can find it quickly. But there were proceedings where the Brown Darrell Clinic and Bermuda Healthcare Services were applicants in the matter. And I think the dispute was in relation to the files of the establishment and whether or not they could be, there was a legal professional privilege, I think, concerned.
I know.
Professional privilege.
Yeah, what happens, the patients brought a case for why
yes,
their files
yes,
were seized by the police,
yes,
from the Brown Darrell Clinic. This is not a case brought by Dr. Brown or by Dr. Reddy. This was a case brought by the patients on the basis.
No, but the applicants, I mean, I can take notice of it. I'll obviously go and look for it because I gave a written ruling at some stage of those proceedings. But parties to that matter included, I'm relatively certain I'm correct. I mean, I'll find out obviously when the case was before me, but the Brown Darrell Clinic and Bermuda Healthcare Services were parties to those proceedings. And your firm was on the record. It might have been Mr. Duncan. I vaguely recall at some stage of those proceedings that you addressed the court. But anyway, I raise it for you because—
No, Mr. Pettingill, I think, was instructed.
He was instructed by the other side, by one of the patients, I think.
He was instructed by the patients.
Who was acting in a representative capacity, but also parties to those proceedings. Anyway, I'm raising it for you. You can perhaps have a look at it over the lunch hour and see whether or not there's anything arising out of that, my having sat on those proceedings that you would like to address me on.
All right, I'll do that.
Miss Christopher.
Can I?
Sorry, you're on mute.
Forgive me.
I believe that Mr. Duncan
Would it be more
got the
helpful to have Mr. Duncan?
Oh, I'm sorry. I thought Mr.
Yes.
Duncan, I'm Mr. Duncan, no discourtesy intended. I had misunderstood and had the impression that you were just merely going to formally adopt the submissions of Mr. Lynch, but are you going to make submissions yourself?
Yes, I will do, milady.
Okay.
First of all,
Can I get just some indication? Are you likely to go into the afternoon or?
No.
Okay. And also, I'm going to ask for the indulgence of all the parties. I'm going to take a 5-minute break and then we'll come back at 12:30.
Okay.
Okay. Thank you, Ms. Oswald. Can I resume? Sorry, one moment. I just want to make sure Court Smart's on.
Yes, sorry, yes.
Yes? Okay,
Yes.
thank you.
All right, thank you.
Yes, thank you, Mr. Duncan.
Thank you, my lady. First of all, in the civil proceedings with which this application has now been consolidated, I should say that we assume that for the record, the documents filed in those proceedings commencing with your order dated the 14th of May are now incorporated into these proceedings. So that loosely includes the order of the 14th of May, the informal submissions, the affidavits, the more formal submissions that have been made by Mr. Lynch, the submissions of Malone and Friends for the Crown, Miss Christopher, and Mr. Richards. So those now are formally in the record for the purposes of our submissions. And we would like to start by first adopting wholesale in the civil proceedings the submissions that Mr. Lynch has made. So they are now formally, both in writing and orally, incorporated in the civil proceedings.
Yes.
We now propose to make a number of short points on the back of that incorporation of those submissions. First, we join with Malone and Friend Mr. Lynch and invite the court, based on the authorities he referred to at the start of his submissions, to provide a set of facts, however long or short it is, that you will be relying upon in order to arrive at your determination. We note, my lady, that during the course of Mr. Lynch's submission, you asked whether that should be given in your ruling or before. We support the submission that it should be provided before so that we can reply to it. We say that if it's found in your ruling, we can make no submissions on it. So we support that approach wholeheartedly. Next, my lady, we would like to make a number of points, two of them in response to the submissions filed on behalf of the third respondent, and one in response to a comment that you directed to Malone and Friend Mr. Lynch. First, my lady, do you have these submissions produced by Malone and Friend Mr. Richards?
Yes.
Dated 7th of June, 2021.
Yes.
Lady, if I could ask you to look at paragraph 10 of those submissions. This is a short, discrete point.
Yes.
You will recall that Mr. Lynch set out his submission on the basis of two strands, one with respect to Dr. Sabir and the second with respect to Justice Mussenden in his former capacity as DPP. The argument being made in paragraph 10 appears to be that once it was known by the applicant that the DPP was involved in the investigation, objection should have been taken at that point. We shortly say that that would have been rejected on its face. First, there may have been no decision to prosecute. And second, any application would no doubt have been faced with the court's injunction that not only was the application premature, but the application could have been made in the criminal trial. We would have been told, you cannot make that application now. Now would have been the time. You cannot make the application whilst the investigation was going on. The time to make the application would have been now. Another short point we make is with respect to the submissions filed by my learned friend, Miss Christopher.
Yes.
On page 6 of her submissions, there is reference to the case Saxmere Company Limited and others versus Woolboard Disestablishment. It's a 2009 case. I take you to that page, in particular, paragraphs 7 to 10 referred to on that page, because the submission that is being made is that the relationship between yourself and Mr. Mussenden must be seen in the context of rules that relate to the independent bar in the United Kingdom. If you briefly read paragraph 7A through to paragraph 8, 7A to paragraph 8 over the page.
Sorry, which page in Saxmere are you referring to?
No, I'm referring to your submissions. There's a
Okay.
reference to your submissions on page 6 to paragraph 7.
Right. Okay. I'm there.
Yes, I think her ladyship is still reading over the page.
Yes.
It's a short point, my lady, and it is that the reference to the independent bar is the wrong test as applied to the Bermuda bar. Bermuda bar is not an independent bar in the same way that the court is referring to the UK bar or indeed the New Zealand bar in that authority. The Bermuda bar is governed by the Professional Code of Conduct, in particular, the section beginning section 22 on conflict of interest. Those rules are designed to deal with not only the conflict with respect to information that can arise between partners moving from one firm to another, but also in relation to the financial and other interests that are connected when people are in partnership, as opposed to being members of an independent bar. So I just bring that to your attention to say that that is not the correct analysis, we say, and the reference on page 6 is incorrect. If you want a proper reference as to how the court should view relationships between existing and former colleagues within law firms, the appropriate reference is the section within the Professional Code of Conduct in the attached to the Bermuda Bar Act, and in particular, assistance may be gleaned from section 24A of the rules. That section deals with past relationships between members of the bar. The last point I want to make, milady, is in relation to a comment that you directed to Mr. Lynch with respect to whether there was any difference in the impact of the alleged relationship he is attacking between yourself and your father, because this is a jury trial. And as a consequence of being a jury trial, you're not I assume the point that was underlying that is that you're not the ultimate finder of fact in the determination of guilt or innocence. Milady, with respect to the civil case, the one that I appear in, you will be the ultimate determining finder of whether or not there is indeed a breach of the Constitution or not. Milady, in that case, we take the view that this jurisdiction faces possibly one of the most serious constitutional challenges it has ever faced.
Sorry, Mr. Duncan, to interrupt you, but just so that you can address the context of what was actually a question to Mr. Lynch.
Yes.
Was in relation to his concerns about the assessment of Dr. Brown's credibility. And so I was asking for him to assist me in how he says that exercise would feature in a jury trial. So it really is specifically in relation to the assessment of character and credibility.
Right, milady, and that was also, I understand, in the context of the degree of influence he is alleging may arise with respect to the relationship that you have with Mr. Mussenden, Mr. Justice Mussenden. Is that correct?
Is what correct?
That part of the concern is with respect to the relationship that you also have.
Oh yes, I understood him to rely on the entire pool of facts.
Yes, that's
to launch his concern that there is an appearance that I would be adversely influenced in any assessment of credibility or character in relation to Dr. Brown. That's as I understood his submissions.
Yes, and I'm correct in thinking that your point may have been that as a result of there being a jury interposed in the ultimate determination, there may be less of a concern that should be had on the part of the applicant. Is that correct?
No, I wasn't making a point. I was asking him, how does that, sorry, I want to be careful to clarify.
Yes.
I was asking him to address me more specifically as to how how the assessment of Dr. Brown's character or credibility, when that would feature in the context of a jury trial. You obviously want to address me as to how I might assess the character or credibility of Dr. Brown in the context of the constitutional application.
That's correct, yes.
Yes, it was just a question.
And I say with no disrespect, regardless of the question, the point still is good that we have to make, namely that with respect to the constitutional application, as I was saying, this jurisdiction faces what we say is probably one of the most serious constitutional challenges it has ever faced. And it involves an issue that goes to the very root and foundation of the Constitution, namely whether or not there is a separation known in the classical sense as a separation of powers between the executive branch of the Constitution and the other branches of the Constitution, and whether within that executive branch there is a separation between the office of the DPP and the deputy governor. The lady will be aware from the constitutional motion, I don't know whether you have it to hand, and if you do, I'd like to take you to paragraph 15. I won't ask you to read through the whole document, but just paragraph 15. And you will see that the concern we have is that the evidence from the police, is that for a number of years, at least once per month, commencing 2013, the investigation team, comprising police officers from Bermuda and the United Kingdom, reported into a group, loosely known as a group as described by the Bermuda Police Service. That group comprised the DPP, the Deputy Governor, the UK Overseas Territory Law Enforcement Advisor, and the Commissioner of Police. Now, the Deputy Governor is constrained by powers under Section 19 of the Constitution, and the DPP has a constitutional obligation to exercise independence in his role under Section 70 and 71 of the Constitution. And it is our case that the DPP was subject to influence in the exercise of his role in the investigation, and that for part of that period, it included Mr. Justice Mussenden. It started with Rory Field, it included Mr. Justice Mussenden, and then for a few days at the conclusion of this investigation, it was the current DPP. But we say that that is a serious constitutional breach, and it involves your former partner, who we say clearly on the evidence was not exercising his role independently. And it would behoove, we say, this court to ensure that there is no appearance or connection between the judge who is going to make a determination on the constitutional issue and the very person who is under challenge, namely the DPP, for a breach of his constitutional obligation to exercise his functions independently. And the test, which is not too distant from the test that my learned friend, Mr. Lynch, has been advancing in the criminal case, is that there cannot be an appearance that the DPP has been influenced in the exercise of his role, particularly by another member of the executive with political connections. And so the more layers we peel off this particular scenario, the more incumbent it is that the court takes every opportunity to ensure that there is the...
I'm sorry, Mr. Duncan, just before you do leave that point, is it the case of the applicant in the constitutional proceedings that the undue influence on the DPP was motivated by some hostility some personal hostility that he bore for Dr. Brown?
No, we've not alleged that
Okay.
in that case.
Yes, thank you.
But unlike the application that's being made now, we don't need to allege that. The test is a different one under the Constitution because of the nature of the importance of the separation of the executive functions. All we have to demonstrate, and the authorities show that, is that there was a potential that in the exercise of his or her functions, the DPP, that there is the appearance that the DPP could have been influenced. So we don't need to establish the test at the same level that is being advanced now, but we bring it to the court's attention because it is the same person in the DPP who is the subject of the challenge that is being made with respect to the conflict. And it just adds another layer that we say should make the court very concerned about proceeding in the event that there is this level of concern about the appearance of not the actual bias, nobody's alleging you're actually biased, but the appearance of bias in this case. So, my lady, I don't think I have any further submissions. I just, as I said, support and ask the court to adopt in the constitutional motion all of the submissions that Mr. Lynch has made, in addition to the few points I've just made as well.
Thank you, Mr. Duncan. Ms. Christopher, I will obviously hear from you this afternoon, but can I get some indication if there's concern that we will not finish this afternoon? It seems to me that we should be able to get through the responses, but I might be wrong.
I don't anticipate I'll take longer than an hour and a half. As you can see, my submissions are only 8 pages long, and I really sought to identify all the issues that I have, but my learned friend had said was saying there. So, you know, I'm in the court's hands, though. I can't guarantee, but I don't anticipate I'll take longer than that.
Thank you. And Mr. Richardson, Steele, anything you want to add to?
I think I'll be about 10 minutes, my lady,
Okay.
at most.
Likewise, my lady.
Okay, thank you. All right, so we can come back at 2:30.
Yes, ma'am.
Yes? All right, thank you. Adjourned.
Elroy, I think that's you. You're not muted.
Thanks.
No worries.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, everyone.
Good afternoon, Mr. Duncan.
Afternoon.
Good afternoon, Mr. Moody.
I'll join in. Good afternoon, everybody.
I wonder if you were going to say something. Well, you've got an hour and a half apparently to say something.
Yeah, I thought I'd get out of the way now and save time.
Yes, good afternoon, everyone.
Good afternoon, my lady.
Good afternoon.
Before Miss Christopher addresses you, I have taken the luncheon adjournment to look at the case that you mentioned, where you were where you gave an extempore ruling on the matter, which was there was an intervener by the name of WF.
I read it actually.
Oh, right. Okay. Well, all I wanted to say is that in respect of that matter, you will appreciate, I think I appeared on one occasion.
You held for Mr. Pettingill on behalf of the intervener applicant.
That's right. Yes. And we sought to obtain an adjournment so that all the JR and all the other matters could be dealt with together. You refused that application. I then, I think, sought to try and find agreement with Mr. Deal, who was acting on behalf of the police. And in fact, we were able to find agreement so that when we came back before your ladyship, although I tried to reopen the arguments, you didn't permit that beyond the normal courtesy that you extend to counsel. And then you then made an order that was in agreement with the protocol that we had agreed, that is Mr. Deal and I on behalf of the applicant or the intervener. So to the extent that your ladyship was exercised in such a matter, it did not involve Dr. Brown, although of course one of the applicants.
I mean, that's not entirely true, is it, Mr. Lynch? Because the first to third applicants of this, there were, because Bermuda Healthcare Limited Services and Brondero Clinic were applicants in those proceedings. The history of the proceedings is laid out in the ruling.
Yes.
You're dealing with your involvement, your limited involvement, in fact, holding for Mr. Pettingill. But the fact of the matter is that the applicants, the parties to those proceedings included the Brondero Clinic and Bermuda Healthcare Services.
Yes, I mean, obviously different legal entities, and they were there on behalf of that company, securing the files on behalf of that company that were patient files.
Yes, and the underlying investigation is the same investigation that underlies these proceedings.
No,
it's completely different. Completely different. The investigation was in relation to what was described at the time as being the over-testing of patients, and the police warrant was obtained in order to secure files of patients that had been tested either through CT scans or MRI scans. That was the basis.
Those allegations were not as against, I thought I had seen it set out in a narrative I gave for the evidence that was before the court. Those allegations were also as against Dr. Braun and his wife, Miss Wenda Braun, I think it is, Henton Braun.
Yes, in relation to their directorships of the companies.
Okay.
But
to say
it's important to look.
At all, is that a fair characterization?
I'm sorry, say that again.
Is it fair to say that that had no involvement with Dr. Braun?
Well, it was part of an investigation, a process in the obtaining of a warrant by the police that was being challenged. The problem here was that it first of all, it didn't directly involve Dr. Brown. It involved the clinics of which Dr. Brown was not an active doctor at the clinics at that time. Dr. Reddy was. Dr. Sanapa Reddy was the acting doctor working for those clinics. And that is why he is named on the action, on the civil action, rather than Dr. Brown, because he was the doctor said to be ordering particular scans. The company, of course, is owned by Dr. Brown, and it's important to note that, of course, none of this has actually resulted in any charges being brought.
No, I accept that. But Mr. Lynch, and I can assure you, I'm not debating you, but I do want you to have the opportunity to address me on anything that appears to me potentially relevant to a recusal application. What caught my attention was the summary. Do you have the ruling?
I do. I've got it in front of me.
Okay. So I'm looking at page 2 of the ruling where I do a summary of what the police investigation was, and I summarized the second affidavit of Detective Sergeant James Hoyt, sworn on the 31st of May, 2018.
Yes.
And if you can, I mean, I don't know if you need to have a quick read through that or if you've seen it already, but that's essentially what I was referring to.
Right, that it followed an investigation.
Sorry?
Yes, it was an investigation into Dr. Brown's activities at the clinic, dating back some time, not of antiquity, but was more contemporaneous to the events at the time. But
Lou, hi. Did Dr. Brown swear any affidavit evidence in that proceeding, the 2017 proceeding?
I don't believe so. I don't think there was any evidence from Dr. Brown in relation to that.
Well, let me just say, I don't.
Gail was speaking.
It came to my mind. I thought it was proper for me to raise it so that you have the opportunity to address it.
Yes, no, I appreciate that. May I make the position clear that at the time, what had happened, as I understood it, was that there was a warrant which was being pursued by the police in relation to the seizure of certain files related to the alleged over-testing of patients. Those files having been seized, an injunction was sought immediately to prevent the police examining them. It came before your brother judge. His name escapes me for the moment.
Justice Hellman.
Hellman, thank you. Yes, who then I think shortly later after left the jurisdiction, the matter fell to you, and I was asked to make an application at the last minute in order to seek an adjournment on behalf of the interveners. As I understand it, the only issue that arose was whether or not the police were entitled to examine the files, patient files, and what was being sought to do was to prevent that examination. An injunction had been granted to prevent that examination, and my understanding of what then transpired was that we had come to an agreement ultimately as to how many files could properly be examined in the first instance, which, as I understood it, your ladyship, as it were, endorsed that agreement in the ruling that you gave.
Lady, I'm hesitant to interrupt my learned friend. I'm quite happy to deal with this in my submissions, but perhaps it might be best if I put our position now, and then my friend has the opportunity of dealing with it now.
Well,
Dr. Brown,
before we start, I just wanted to make one minor point, which I should have made at the start for the purpose of the record, and that is that I appear with Mr. Hawthorne. I don't think that was mentioned by the court clerk at the start. I just wanted to make that point for the record, just so that everybody's aware I'm appearing with him.
Yes, thank you.
Yes.
Bill.
Thank you, my lady. Dr. Brown did swear two affidavits in it's case numbers 2017 number 51 He swore an affidavit on the 23rd of March of 2017. He swore a second affidavit on the 20th of April 2017. And I would, and maybe my memory is failing, it wouldn't be the first time, but my recollection is, my lady, when we appeared in front of you in relation to issues in relation to the protocol, my recollection is that we had agreed, to be fair to my friend, most of the issues in relation to the protocol. There were some matters that we agreed to disagree on, and your ladyship ruled on those issues in the protocol. So it wasn't quite as cut and dried that we had agreed all the issues on the protocol at all.
Sorry, what was the last part of what you just said?
It wasn't cut and dried. Your ladyship may remember we came back in front of you with the issue, what we called the protocol,
yes,
which was, as my friend has said, how many files were going to be released, how they were going to be examined, et cetera, and we had agreed, my friend and I had agreed some of the points, but hadn't agreed all of the points. And my recollection is, and I stand to be corrected, I can't say this hand on heart, this is my recollection, is that we appeared in front of your ladyship and basically hammered out those points that we
I think I even did a separate protocol ruling.
I think you did, my lady. Yes, that's what I was coming to.
Okay.
So yes,
it's in paragraph 78 to 81.
Yes. So it wasn't as cut and dry that basically you were there to preside over an adjournment application. It was a bit more. It was considerably more in depth than that.
Well, if I could
I'm not sure that's right. There was a dispute between us. I think it was ironed out at the last minute. If you go to paragraph 71, you can see that your ladyship says that on Thursday, the 14th of February, Mr. Lynch confirmed that the parties had achieved an agreed protocol without prejudice to his primary objection to the making of the protocol. Mr. Lynch reiterated his objections to approving the protocol without favour from the court. Mr. Lynch QC made submissions on the importance of doctor-patient confidentiality, etc. Having heard Mr. Lynch's submissions, I declined to make any findings on issues pleaded under the substantive judicial review application. Mr. Lynch agreed that his primary objection to the court's approval of the protocol was on the same basis and was inextricably linked to the grounds upon which the truthfulness of the search, the lawfulness, of the search warrants was challenged. I subsequently approved the proposed protocol placed before the court. I mean, I don't think much turns on this, to be fair. The short answer is this, that when this first came before the court, as my learned friend has said, I don't recall seeing the affidavits of the of Dr. Brown. I'm sure there were, as he tells us that, I'm sure that's right, but they're dated 2017. It's before your ladyship became involved in the case, at a time when, as I understand it, when the matter was before Mr. Justice Helm. Look, if the point of all of this is to say, well, there's been a case before me on a previous occasion in which I dealt with matters concerning Dr. Brown and no objection was taken to my refusal at that stage, then of course, in the sense that Dr. Brown was the subject of warrants for the seizure of items from his business premises that related to patients, yes. In the sense that it didn't directly concern him beyond the fact that it was part of an investigation. The warrants were obtained as part of an investigation into his activities. No objection was taken at that time. I didn't, at that stage, represent Dr. Brown. And all I can say is that I'm seized of this.
Who was represented by Mr. Well, the Bermuda Healthcare Services and the Brown Darrell Clinic Limited were represented by Mr. Duncan.
Yes.
In those proceedings.
Yes. It's not for me to second guess what might or might not have been thought at that stage. All I would say is that our position is quite clear, and I hope that I've made it as clear as I can. If there had been some previous representation representing Dr. Brown in his corporate capacity rather than in his personal capacity, then it's a matter at that time for a pragmatic view to have been taken. I certainly, for my part, having been seized of the case on behalf of Dr. Brown, specifically in his personal capacity, take the objections that I do at this stage. What value can be placed on a hearing which first reared its head before a different judge and then was transferred to your ladyship as a result of that judge, as I understand it, leaving the jurisdiction, is a matter entirely for you, and perhaps Mr. Duncan can assist you in any further if you need it.
Thank you.
Milady, I just make 2 points. The first point is that the matters that were before you were involving the corporate entities. They didn't involve Dr. Brown in his personal capacity. And the second point I make is the one that's already been made by Mr. Lynch with reference to your decision. You made no determination on the underlying matters with respect to the judicial review application. I don't think I need to go any further than that.
Thank you. All right, so shall I hear from Ms. Christopher?
Yes, my lady.
Thank you.
I must say at the outset that I was disinclined to be making any formal submissions in connection with this matter. By going through my learned friend's authorities, it seemed like there was a totally different thread that was running through my learned friend's authorities in connection with the issues at hand, as opposed to what was set out in his submissions. So we did decide to make observations, I guess, because ultimately we consider that this is a question for you, my lady, and so we're really just making comments on the authorities and the facts as we see them. If you can look at page 1 of my written submissions, to be quite frank, I don't really see where the facts as relied to by my learned friend, which are set out, I believe, at paragraph 22, 23 of his submissions, support the idea that either your father has antipathy towards Dr. Brown, or that you, by extension, would have antipathy for Dr. Brown. And I don't want to make a bunch of hay about that, because my position is, even if he did have that antipathy, it's very far-fetched and has no support in law to suggest that that should affect whether or not you would recuse yourself in this instance. I simply avert to the fact that it's a failed business deal from 25 years ago, which, if you listen to Dr. Brown and Dr. Warner, they suggest that Dr. Subair was the malfeasant, and I don't understand why he would have antipathy towards Dr. Brown or anybody else in that arrangement. So I don't even think that part of it gets off the ground. With respect to Mr. Mussenden, I tried to dissect the allegations that are being made with respect to his situation. And I've distilled that at the bottom of page 1, that the former DPP and the learned judge, you, my lady, were and remain close friends. The former DPP was not reaffirmed as the AG when the defendant was appointed Premier of Bermuda, and I made the observation that that was 15 years ago, I believe, in 2006, and that the former DPP spent many years as an active participant in the prosecution team known as JIPT, the Joint Investigative and Prosecution Team, the subject of which is a separate constitutional claim for breaches of the constitutional guarantees. So now the uncontroverted test, I think we all agree on, is that set out in Porter and McGill. The test for apparent bias is whether the fair-minded and informed observer, having considered the facts, will consider that there is, and I underline, a real possibility that the judge was biased. And I will show that my learned friends fail at that very first hurdle. In respect of 1 and 2, while we cannot speak to the extent of the parties' friendships, it is inconceivable, given their respective offices, that they would discuss matters likely to come before the court. In respect of 2, which is the ground to do with not being appointed as or not being reappointed to the position of AG when Dr. Brown took office as the premier, that somehow that would make Mr. Mussenden have antipathy towards Dr. Brown. I do join with the concept that it's very strange that if it was felt that Mr. Mussenden, Mr. Justice Mussenden, had that sort of antipathy, that that was not raised during the course of the constitutional proceedings, that it is now not relevant. It's not relevant because it wasn't raised. So I would submit that not much weight should be given to that. And yes, it is very ordinary that when new people assume office, there's a new premier, he appoints his own team. I don't see where one can assume that Mr. Mussenden would have antipathy for that. It's just, one day you're in, the next day you're out. You pack your bags, before an election, because you may not be there the next day. I don't think that anything should be drawn from that 15 years ago, but in any event, Mr. Mussenden has enjoyed tremendous success since 2006. So it would seem to me that at the current stage, to suggest that he had some antipathy that would somehow translate to this trial judge is unrealistic, really. So my learned friend, during the course of their submissions, referred to Pinochet, and I'm going to refer to what my learned friend quoted from Pinochet, because in that instance, I guess he referenced the 2 limbs in Pinochet at paragraph 13 of his written submissions.
Yes.
1, the fundamental principle is that a man should not be a judge in his own cause. This principle, as developed by the courts, has 2 similar but not identical implications. First, if applied literally, if a judge is in fact a party to the litigation or has a financial or proprietary interest in its outcome, then he is indeed sitting as a judge in his own cause. And I'm going to say the reason I raise this is because many of the cases that my learned friend referred to during the course of his submissions were under what I would describe as limb 1 of Pinochet. In that case, the mere fact that he was a party to the action or has a financial or proprietary interest in its outcome is sufficient to cause his automatic disqualification. The second application of the principle is where a judge is not a party to the suit and does not have a financial interest in its outcome, but in some other way, his conduct or behavior may give rise to a suspicion that he is not impartial. For example, because of his friendship with a party. The second type of case is not strictly speaking an application of the principle that a man must not be a judge in his own cause, since the judge will not normally be himself benefiting, but providing a benefit for another. And then paragraph 14 says, we make it clear at the outset that this application is predicated on the second of those limbs. Now, my learned friend went to the case of Lockerbie, page 480, I believe it was. Because at that stage, they, whilst not attempting to give a definitive list of instances when it could be felt that there was bias, they did attempt to assist the court with the scope of what it should be considering. And I note that you, my lady, asked my learned friend to assist us with what category it is being suggested that you fall in the context of the facts as we understand it in this case. And I've yet to understand an answer to that question. The one thing that case says is that it certainly just can't be by virtue of being a membership in the judge's family, for example. It says, we cannot, however, conceive of circumstances in which an objection could be soundly based on the religion, ethnic or national origin, gender, age, class, means, sexual orientation of the judge, nor at any rate ordinarily could an objection be solely based on the judge's social or educational or service, employment background or history, nor that of any member of the judge's family. So I'm trying to understand why it is felt that somehow by going down any further, having effectively, we say, excluded you, my lady, under the inconceivable circumstances, that you're sort of brought into anything vaguely reminiscent of, well, what could constitute an instance of bias. And it specifically says in Lockerbill at paragraph D on page 480, by contrast, a real danger might be thought to arise if there were personal friendship or an animosity between the judge and any member of the public involved in this case. I don't understand where it's being said that that obtains either a personal friendship or an animosity between the judge and any member of the public involved in the case, or if the judge were closely acquainted with any member of the public involved in the case, particularly if the credibility of that individual could be significant in the decision of the case. And I'm trying to ascertain where it is being suggested on the basis of the civil proceedings, where it is being suggested that Mr. Mussenden's credibility is going to be drawn into issue such that it would even ever be considered that it's appropriate for the court to recuse itself. I will speak more specifically in terms of your respective offices with respect to that point, but I don't believe that my learned friend has gotten over the hurdles that he would need to get over to bring this court to consider it.
Yes.
And I would further invite the court to look down at under paragraph F on that page.
Yes.
Which, if you look at up under paragraph D, by contrast, a real danger of bias might well be thought to arise if, and then if you go down just below paragraph F,
Mm-hmm.
or if for any other reason there were any real ground for doubting the ability of the judge to ignore extraneous considerations, prejudices, and predilections, and bring an objective judgment to the bearer on the issues before him or her. So I don't understand why. I don't think anything has really been articulated, I guess, to bring us within the scope of my learned friend's authority, Lockerbill. So if you look at my submissions, middle of page 3, in the instant case, there's obviously no conflict between you and any of the parties that has been shown, no interest of yours that is advanced by you acting, no antipathy, even inferentially ever shown by you towards the defendant. There's no instance where it could be suggested that there could be doubt. That's why I guess I referred to the quote that my learned friend had given. Mm-hmm. Which states in most cases, it's at paragraph 20 of his thing, and he emboldened it. In most cases, we think the answer one way or the other will be obvious. But if in any case there's any real ground for doubt, real is an important word, that doubt should be exercised in favor of recusal. That passage is at paragraph G of page 480.
Yes.
So if you look at that paragraph, the mere fact, if you're starting at G, the mere fact that a judge earlier in the case or in a previous case had commented adversely on a party or witness or found the evidence of a party or witness to be unreliable would not without more found a sustainable objection. In most cases, we think the answer one way or the other will be obvious. But if in any case there's a real ground for doubt, that doubt should be resolved in favor of recusal. So I'm inviting you to consider that my learned friends really need to bring this court within the scope of some recognized principle, some recognized part of the authority, so that this court will feel that in the circumstances it ought to recuse itself. I then provide the only real case that is not my learned friend's case I'm referring to, which I refer to only because it's the only case that's not, for example, an arbitration with different considerations, where the issue has been considered in some depth, and that is the case of Athene Holdings.
Yes.
I don't think you can exclude the substance of Athene Holdings by making an observation that Mr. Potts didn't raise it until after he received an adverse ruling, because really I don't consider that to be an issue that's dealt with in any of the real substance of the decision.
Ms. Christopher, sorry, I think I have lost a grip on my copy of Athene, and I suspect it is, just give me 1 minute, please.
Former lady.
Yes, thank you.
Yes, my lady. So in Athene, really the issue with respect to the application for recusal really starts at paragraph 42,
Yes.
page 15. And in that instance, it was being sought by Mr. Potts to suggest that the Chief Justice recused himself on the basis of an apparent bias or predetermination. And I believe he was relying heavily on the Chief Justice association with the law firm that he used to previously act for, as opposed to anything else. So if you look at paragraph 43, in considering this application, I remind myself of the test of apparent bias, which I take from the recent judgment of Justice Turner in Miley versus Friends Life Limited, the 2017 case. The law relating to apparent bias is uncontroversial and is set out in the defendant's submissions. The test for apparent bias is whether the fair-minded and informed observer, having considered the facts, will conclude that there's a real possibility that the judge was biased. In Hilo, 2008 case submitted by my learned friend, Lord Hope described the attributes of the fair-minded and informed observer at paragraphs 1 to 3 of the speeches. Those paragraphs include the following abstracts. The observer, who is fair-minded, is the sort of person who always reserves judgment on every point until she has seen and fully understood both sides of the argument. She is not unduly sensitive or suspicious. Her approach must not be confused with that of a person who has brought the complaint. The real possibility test ensures that there is this measure of detachment. The assumptions that the complainer makes are not to be attributed to the observer unless they could be justified objectively. And that's what I'm inviting the court to look for here. And that is why I was underscoring my concern that my learned friend failed to articulate something quite clearly out of what is set out under Lockerbell. But she is not complacent either. She knows that fairness requires that a judge must be seen to be unbiased. She knows that judges, like anybody else, have their weaknesses. She will not shrink from the conclusion, if it can be justified objectively, that things that they have said or done may make it difficult for them to judge the case before them impartially. At the risk of stating the obvious, any judge who is invited to recuse himself on the ground of apparent bias must be very careful not to allow any personal considerations whatsoever to contaminate his conclusions. And to be frank, my authorities or my learned friend's authorities will show that that goes both ways. Nonetheless, this should not preclude such a judge from acting with the same level of robustness and proportionate skepticism, where this is necessary, as he would approach any other application. So that is my invitation to you to bring what I would describe as the robustness and proportionate skepticism to an allegation of bias in respect of this particular instance. To proceed otherwise would be unfairly to prejudice the other side out of an undue sensitivity to the perception that such robustness may be wrongly attributed to the personal feeling of the judge, as opposed to the legitimate demands of firm management with the aim of applying the overriding objective. So I'm inviting the court to consider fairness to the respondents in this instance by being robust and being proportionately skeptical of what my learned friend has said. The court then, at paragraph 44, one moment, took us to the Locker Bill, where then it draws conclusions based on the case of the President of the Republic of South Africa and South African Rugby Football Union and others, a 1999 case.
Sorry, what paragraph are you in? Oh, I see, you just said below.
Yes.
Yes.
Where even Lockerbell considered, even though these observations were directed to the reasonable suspicion test. It follows from the foregoing that the correct approach to this application for the recusal of members of this court is objective, and the onus of establishing it rests upon the appellant. And I would underscore that. The question is whether a reasonable, objective, and informed person, and we say that, you know, it's one thing to say the judge's father had a fuss with the defendant, but when you say 25 years ago, and when you point to some of the factors that we have pointed to at the outset, you will understand why an informed person is a reasonable part of the test to be considered. The question is whether a reasonable, objective, and informed person, what are the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. That is a mind open to persuasion by the evidence and the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judge. And I think one of my learned friends' cases, I said the judge's oath is not a panacea. We're not using it as a panacea, but it is going to be thrown into the mix. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by judges to administer justice without fear or favor, and their ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. And that is a duty that brings out a clarion call, I say, to this court. And even if you look at the Judicial Code of Conduct, one of the items they have there is that you have to be careful not to, you have to be mindful of the fact that where this court recuses, that puts a burden on somebody else. They must take into account the fact that they have a duty to sit in any case where they're not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of a litigant for apprehending that the judicial officer, for whatever reasons, was not or will not be impartial. So we don't shy away from any part of that. one of the authorities that my learned friend proffered up, and I noticed that my learned friend didn't actually refer to it during the course of his submissions. It's the case of Stubbs. Let me just find it in the bundle.
Yes, I have it.
I believe it's maybe 5 or something. No, that's not it. One moment, my lady. $13. Yeah, tab 13 of the bundle.
Yes.
And in particular, in that case, I refer the court to paragraph 34. In the present case, the Court of Appeal was clearly concerned that submissions based on apparent bias should not be accepted too readily. It may well be that members of the court were influenced by their experience of wholly unmeritorious applications for recusal in other cases. In this regard, we note that one ground of appeal advanced by Evans before the Court of Appeal in the present case was that the trial judge should have recused himself after sharing emails with the Crown with reference to the trial to the exclusion of the appellant and or his counsel. It appears from the judgment of the Court of Appeal that this refers to no more than one unsolicited email sent by prosecuting counsel to the judge containing a list of authorities he proposed to cite the next day, which hadn't been copied to the other parties and for which the prosecutor was duly reprimanded when it was brought to the judge's attention. The board wholeheartedly agrees with the Court of Appeal that a judge should not recuse himself unless there's a sound reason for recusal, lest unmeritorious applications for recusal become the norm and result in damage to the administration of justice. In particular, it is necessary to stand firm against illegitimate attempts to influence which judge shall sit in a particular case. And I note whether or not we have to go abroad and get a judge. The board is also conscious that the limited size of the Court of Appeal in some jurisdictions, such as the Bahamas, can make it difficult to avoid accidental listings before judges who have had some prior involvement with parties or with earlier stages in the proceedings. However, for the reasons stated above, the board is of the clear view that the complaint made by the appellants is well-founded. In its view, the decisions of Mr. Justice Isaacs made during the second week of trial in that instance would lead a fair-minded and informed observer to conclude there was a possibility he had prejudged issues which fell for consideration on appeal to the Court of Appeal, and that the appellants did not have the appearance of a fresh tribunal of 3 judges to consider their appeals. I believe one of the judges below was actually one of the judges in the Court of Appeal. And then it said in that particular instance, the appeal was allowed. But I underscore with the court the importance of not recusing for wholly unmeritorious applications. My learned friends next pointed to the case of Grant and the Teachers Appeal Tribunal, which is at tab 17. It should be noted that in that instance, the Privy Council decided against those alleging bias. It was stated therein that it is a matter of careful and sensitive judgment as to whether a judge is close enough a friend to make it undesirable for him to act, but he should not make it impracticable to carry out his judicial duties.
Sorry, Ms. Grissom, which paragraph are you reading from?
Yeah, let me just try to locate that. Ready? $38.
Yes.
So if you look at the whole of the paragraph, it is necessary to bear in mind that these remarks of Lord Bingham were intended as guidance for judges in other cases and not as a comprehensive definition of the circumstances in which bias might be thought to exist. And I believe that in that instance, they were referring to the case of Lockabell. The facts of each case are of prime importance, as is pointed out. Their lordships are mindful of the problems which may face judges in a community the size and type of Jamaica and other comparable common law jurisdictions. In such communities, it is commonly found that many of the parties and witnesses who are concerned in cases in the court are known and not infrequently well known to the judge assigned to sit. It is incumbent upon the trial judge, and that's where I come to the quote, where the Privy Council sort of assumes that in these smaller jurisdictions, these situations happen where there is some associations, however vague. I mean, in this case, I can only describe at best the associations as very vague indeed. It is for you, my lady, to apply a careful and sensitive judgment to the question, in particular, I guess, of whether the association with your father or your association with Mr. Mussenden is sufficiently close to make it undesirable. But I do make the observation that in the current case, or in the case at bar, that the question mark about what, or I would describe it as the impugned conduct of what is now Mr. Justice Mussenden, is something that occurred when you were not business partners and when he was in his office and this court was already in judicial office, either as a registrar or a judge. So I submit that once you get to that point, it really doesn't really matter what transpired before. When the impugned conduct is something that occurred subsequently, I don't think it advances the case very much. And I would take you also to paragraph 39. If the judge and the chairman of the board had been close family friends who saw each other frequently, or if they had been regular golfing partners, it would no doubt be much more likely that the real possibility of bias could be thought to exist. And I would say, as concerns recent times, or when this impugned conduct is supposed to have happened, I don't understand there to have been much of any contact, but I don't know. As it is, the judge has stated to the Court of Appeal that there's no special relationship between the chairman and his family, and that he may have encountered him no more than 10 times over the last 20 years. The issues in the appeal did not involve any assessment of the veracity or credibility of the chairman's evidence, and the issues to be decided did not affect his personal position as distinct from that of the board which he chaired. Their lordships did not consider that such a degree of acquaintance in these circumstances would have caused the fair-minded and informed observer of Jamaica to conclude that there was a real possibility or danger of bias. So I'm going to invite the court to think, and if you apply the test that's set out by the Privy Council there, it is really the fair-minded and informed observer in Bermuda. Would not consider that there was any real possibility of bias. Now, we say that if you look at what is set out at paragraph 27 of my learned friend submissions,
yes,
especially when compared to paragraph 26, you will, I think, figure there's a substantial gulf between them. But we also would add that paragraph 27 of my learned friend submission is setting the bar impossibly low. It says, while it is accepted that a particular defendant's subjective opinion as to the risk of bias cannot be determinative, it is submitted that the particular importance to a defendant in criminal proceedings of being tried by an impartial tribunal is. It would follow that a fair-minded and informed observer would take into account the likely effect on a defendant in criminal proceedings where it is possible or even likely that the judge has been exposed to a negative view of his character held by somebody very close. I don't see how the test could ever be that it is possible. And I even likely that a judge is possibly exposed to a negative view of the character of the defendant. I mean, that happens every day. Somebody picks up the newspaper, you know, and if it's true of the judge, what does that mean about sitting a jury? Because how would that situation not obtain for a jury? Are they going to say you can't be tried in Bermuda? Because the jury has possibly been exposed to a negative view of the defendant? My learned friends, paragraph 27 refers to extraneous predilections. The authorities that I've already gone through suggest that we must assume that a judge knows what is extraneous and what isn't. So I would next take the court to the case of Hilo. Again, my learned friend's case, but not really referred to in much depth. At paragraph 30.
Yes.
The alternative argument for the appellant was that there was a real possibility of bias by reason of Lady Cosgrove. I believe she belonged to, kind of similar to, I guess, Pinochet. She belonged to some group that was, I guess, pro-Palestinian, or she subscribed to a newsletter or the like that was had a view.
Just 1 moment. Ms. Aswood, I don't know if you're listening in, but could I just beg your insistence in my office, please? Thank you. Yep.
Right, so the alternative argument for the appellant was that there was a real possibility of bias by reason of Lady Cosgrove, having been influenced by the views expressed in articles and pronouncements founded on by the appellant's counsel. This argument runs into the same difficulty and the lack of an objective basis for the assumption that Lady Cosgrove would have read and been receptive to the views. And I underscore read and been receptive to the views, because we're hypothesizing, or my learned friends are hypothesizing, for example, that either Mr. Mussenden or Dr. Subert expressed the view, and then they're hypothesizing that you would be receptive. It's merely an hypothesis that no reasonable person, we would say, would agree. That assumption also involves the inherent unlikelihood that Lady Cosgrove, despite her training and experience as a judge, would not have been able to put aside what she had read. Going over to maybe page 6 of my submissions. In the unlikely event that there was some inappropriate communication with the judge and another officer of the court, on what objective basis could it be suggested that she would have been receptive? Interestingly, the case of Sexmere Company Limited and others versus Wool Board Disestablishment Company, referred to by the applicant, states at paragraph 6, and that case is at at tab 23.
One moment, please. Thank you. Ms. Crisper, just one moment. Sorry, Ms. Christopher, you can go on.
Right, so this is really talking, I guess, discussing that part of the test from all the way from Porter McGill that deals with the objective observer. Really starts from subparagraph 5.
Okay. I was distracted, so just remind me which case are we
Yeah,
on
so I'm
now?
on Sexmere and
Yes.
Wool, tab 23, paragraph 5.
Thank you.
The fair-minded lay observer is presumed to be intelligent and to view matters objectively. He or she is neither unduly sensitive nor suspicious, nor complacent about what may influence the judge's decision. He or she must be taken to be a non-lawyer, but reasonably informed about the workings of our judicial system, as well as about the nature of the cases, of the issues in the cases, or the case, and about the facts pertaining to the situation, which is said to give rise to an appearance or apprehension of bias. Lord Hope of Craighead commented in Hilo that before she takes a balanced approach to any information she is given, she will take the trouble to inform herself on all matters that are relevant. She is the sort of person who takes the trouble to read the text of an article as well as the headlines. She is able to put whatever she has read or seen into its overall social, political, or geographical context. She is fair-minded. She will appreciate that the context forms an important part of the material which she must consider before passing judgment. The elaboration of the features of the objective observer is, Justice Kirby remarked and Smithson wrote, a reminder to judges, the parties, and the community reading their reasons that the standard that is applied is not simply the reaction of the judges to a particular complaint. It is, as far as it can be, an objective standard, one aimed at emphasizing the undesirability of idiosyncratic and personal assessments of such matters. As the cases show, in such decisions, different judges can reach different assessments and reach different conclusions. The fact that this is so should make contemporary judges aware that ultimately they themselves have to shoulder the responsibility of reaching conclusions on the point and give an effect to them. They cannot ultimately hide behind a fiction and pretend that it provides an entirely objective standard by which to measure the individual case. The courts must be careful not to subvert the hypothesis by ascribing too much legal knowledge to a lay observer. To do so might mean that justice is not both done and seen to be done by a notional representative of the public. On the other hand, if the court does not impute to the observer some knowledge about how barristers and judges commonly interact, it may arrive at a hypothetical opinion of the hypothetical observer, which does not reflect reality. There therefore needs to be added to the facts about the case known to the observer, which I will shortly describe, some basic knowledge of how counsel and judges are expected to act and interact. That information is conveniently set out in Aussie Airlines Party Limited and Australian Airlines Party Limited. While barristers act on a client's behalf, they do so in a professional capacity as their client's legal advocate selected to act in the case for that purpose. Any barrister so selected could have been briefed to fulfill the same task for the opposite side in accepting a brief to act for a client in a particular commercial case. The barrister does not become part of or identified with the client and has no direct or indirect financial interest in the outcome of the case. The barrister acts as such a member of an independent bar. And my learned friend tried to, I guess, say that the local bar is not independent. It may not be independent in an identical way to the UK, but if you look at paragraphs 24 and 24A of the Barristers Code of Professional Conduct that my learned friend alluded to in his discussion, I guess you want to call it, on this issue, those paragraphs, one moment, basically are dealing with, I can read it to the court briefly. A barrister should not act for an opponent of a client or a former client in any case in which his knowledge of the affairs of such client or former client may give him an unfair advantage. And then paragraph 24A is an instance where it just applies that to other members of that particular barrister's firm. So to my mind, when we're talking about the issues that are set out here, in the context of this authority, I don't believe that it can truly be said that there's any relevant differentiation about an independent bar in the way that they're talking about it here, that people in the context of their offices are doing anything improper by having any association with each other outside of work. So I don't understand, for example, 7A, B, and C, where it is being suggested that somehow derogates from what assumptions we should be making with respect to your relationship with Mr. Mussenden in the past and how that impacts us today. And certainly it's the case that if you look at paragraphs, for example, subparagraph D, it is commonplace for barristers who are close associates or friends, and who may even be from the same set of chambers to fight on opposite sides of a case without compromising their professional duties to the interest of their clients. I only make that analogy to say that by the time that anything of consequence occurred in connection with this case, you, my lady, and Mr. Mussenden were no longer in partnership. So I don't understand that even if you did continue to have some personal association, that you would be, I guess, adversely impacted with respect to any rules of conflict. As judges, paragraph E, are usually appointed from the senior ranks of the profession, particularly the bar, it is likely that they will be acquainted and have formed close associations with senior counsel appearing before them. It is also likely that they will have personal and professional associations with many of the counsel appearing before them. These associations between judges and the profession have been said by Lord Wolfe, Chief Justice, speaking for a bench of 5 in the Court of Appeal of England and Wales, to promote an atmosphere which is totally inimical to the existence of bias. Going to paragraph 8, the observer must also be taken to understand 3 matters relating to conduct of judges. The first is that a judge is expected to be independent in decision-making and has taken the judicial oath to do right by all manner of people after the laws and usages of, in that instance, New Zealand, without fear or favor, affection or ill will. Secondly, a judge has an obligation to sit in any case allocated to the judge unless grounds for disqualification exist. There are none here. Judges are not entitled to pick and choose their cases, which are randomly allocated. Making this point in Muir, the Court of Appeal referred to the following passage from the judgment of Justice Mason in Reed JRL, ex parte CJL. It is equally important that judicial officers discharge the duty to sit and do not, by acceding too readily to suggestions of appearance of bias, encourage people to believe that by seeking the disqualification of a judge, they will have their cases tried by someone thought to be more likely to decide the case in their favor. So that very important principle is what I'm inviting this court to stand up for. So I'm inviting the court to apply the principle set up in Sexmare. There was one of the authorities that my learned friend referred to during the course of the arguments before this court that is in their bundle that dealt with the appointment of sheriffs, I believe.
Yes.
The Scottish case.
Miller and Dixon.
Miller and Dixon, right. Which is at tab 7. I just make the observation that that instance is, yes, a classic instance of limb 1 of Pinochet that my learned friend said that they're not relying on. That's an instance where the sheriffs, I believe, were acting sheriffs, and it was the decisions of the acting sheriffs that were set aside effectively as a class. And it was felt that in those cases, the temporary sheriffs, not even acting, temporary sheriffs had an interest of their own to advance, i.e. the likelihood that they would get a permanent appointment. So that is classic, limb 1, Pinochet. And not the limb 2 that my learned friend is referring to.
Yes.
I would also like to take the court to the case of Tocano, which is at tab 25, and a Professori versus Moldova.
Yes.
And I simply make the observation that that particular case is an instance where the judge had threatened retaliation If you look at paragraph 17 on page 3, the applicants did not learn of the composition of the panel until the day of the hearing. They alleged not to have known at the time of the hearing that 3 years earlier, Judge VB's son had been expelled from the school for misbehavior, truancy, and bad grades, an expulsion carried out by the headmaster of the school and by teachers who formed part of the Professori Permecci Foundation. As a result of the incident, the judge had allegedly threatened the school authorities with retaliation. Well, my learned friend says, well, if an association with the son of the judge and one of the parties is sufficient, then it's a great moment. Well, I'm sorry, but in that instance, the judge had threatened retaliation to one of the parties, and we humbly submit that that case is not to be used as an authority because of familial relationship purely, especially where what is being referenced is something that happened 25 years ago. It doesn't take the court anywhere. I don't think that Dr. Suber is alleged to have threatened retaliation, or that you threatened retaliation to Dr. Brown for something that your father did, or I don't know. I don't really get what that doesn't take us anywhere. I mean, just leave it at that. It doesn't take us anywhere. The case of Squigil in Croatia, which is at tab 28. Likewise, involved admitted personal animosity on the part of the judge in question. So if I can just find that. So yes, it involved a traffic matter. But it also involved the personal animosity. I don't think anything should be taken from the fact that Mrs. Justice Simmons recused herself. It really doesn't take us anywhere. I don't know the circumstances entirely in which Mrs. Justice Simmons recused herself. And nor was she obliged to go into any further detail, but alluding to that, another judge recused themselves because they, at the very least, had a close relationship. It doesn't take us anywhere in the context of this particular inquiry. Just looking for the actual passage. In
relation to Justice Simmons' recusal, or in from the case?
I'm just looking for where it was admitted that she had an association in Squigil in Croatia. All right.
Okay.
Right, paragraph 27 of the SKRIJ, maybe, LJ and Croatia. So yes, it was a slight case, but there was admitted animosity between the judge themselves and the applicant's mother. And what we have in this particular instance is not even a similar conglomeration of facts. It's being suggested by the applicant here that there was that there's animosity between the applicant, and the applicant's father, and that really doesn't take us anywhere, we say. And then the case of Croatian Golf Federation in Croatia, which is a 2020 December case, which is not even 9 months old. I think it's important, paragraph 129. that the court note that the applicant's association's misgivings regarding her impartiality are based on the fact that her husband was the president of the golf club against which the applicant association instituted enforcement proceedings with a view to collecting unpaid membership fees. It cannot be overlooked that the dissolution of the applicant association was directly decisive for the existence of that club's debt owed to the applicant association. It is being understood that a debt is extinguished if the creditor no longer exists. And so it seems to me that once again, that is a limb 1 Pinochet case as opposed to the limb 2 that my learned friend is relying on. And so, you know, I think my learned friend are trying to say, well, the association is a bit sketchier. Well, I think that the court is saying actually that the association is quite direct at paragraph 129. And we have no parallel in this instance.
Right.
So in that instance, because of that particular association, it was felt that concerns about the judge's impartiality were objectively, note key, objectively justified. So going to my learned friend's submissions, paragraph 44.
Yes.
The court should not merely be concerned about saying that there's a possibility that animosity such as may or may not exist between the judge's father and the defendant give rise to apparent bias, because that is not the case. I refer the court to the case of Saxmere. The court is not making a judgment on whether it is possible or likely that the particular judge was in fact affected by disqualifying bias. And furthermore, in the case of the Charles versus Friend, the assumptions that the complainant makes are not to be attributed to the observer unless they could be justified objectively. So in all the circumstances, in our observation, we haven't seen, but it's a matter for the court, where it could be said that this is an instance where my learned friends have reached that high point that suggests that this court should be recusing itself. It's not impossibly high, the test, but it's not as low as my learned friend is suggesting, and will be us if indeed it were as low as my learned friend is suggesting. So we say there's grounds to establish that the court should, you know, that is a, I guess, an ethical, moral point, should continue to act as judge in connection with this particular case. So those are my submissions, unless I can assist the court with anything in particular.
No, Ms. Christopher, I think that was very helpful. Thank you.
All right.
Shall I hear from Mr. Deal next, or Mr. Richards?
My suggestion would be Mr. Richards, my lady, if that makes sense. I hope to be very short.
And so do I, my lady, and I hope that I can be heard satisfactorily.
Okay.
And perhaps just a very brief word, less than 3 minutes from me, your lady, at a convenience. After Mr. Richards, I presume.
Oh, I see. Okay. Well, Mr. Richards.
Yes,
After it's pointed to the direction.
I hope that you can hear me clearly.
Sorry, thank you.
I've really said anything of substance, so I hope that I can be heard. I don't recall ever having had the opportunity before to adopt any submissions made by my learned friend Ms. Christopher, and it's perhaps of the nature of our normal professional interactions that I'm unlikely to have that opportunity again, particularly soon. But I do respectfully and sincerely seek to adopt the very detailed submissions that she has made in relation to the various authorities that your ladyship has to consider. And I don't think that I would be assisting the court greatly by reiterating those submissions in any great detail. I do have, however, just a few observations that I hope to make briefly before concluding my submissions before you today.
Yes.
And I thought I would just make some comments in relation to my learned friend Mr. Lynch, Queen's Counsel's opening 3 points. Your ladyship will recall that he first took you to the postscript in El Faraghi and El Faraghi,
Yes.
which I recall is actually at page 32 of the judgment. And I must confess to some uncertainty as to exactly what my learned friend was trying to extract from his reference to that part of that authority. Because in my respectful submission, it's clear that the principal focus that the Court of Appeal had in that case was what it described as the invidious possession of a judge who was required to sit in judgment on his own conduct in a case. And that's conduct in a case, not conduct of a case, in my respectful submission, importantly, because as my learned friend Mr. Lynch did recognize in his submissions, the whole foundation for the application that the judge in that case should recuse himself was as a result of certain inappropriate remarks, which it was contended he had made at a preliminary stage of the proceedings. And there is no suggestion, of course, that there is any similar foundation for the application that is being made to your ladyship. So your ladyship isn't being asked, as the judge was in that case, to sit in judgment of your own conduct. And so in my respectful submission, that scenario and what is said about it in El Faraghi and El Faraghi is not particularly pertinent to the situation that confronts your ladyship and the decision that you are called upon to make. I do accept the relevance of what is said in Lochabail, and it seems respectfully that there is really not a great deal of difference between the parties as to what the governing principles are here. There is perhaps a more significant difference as to the emphasis which is properly to be placed on the different elements of those authorities. And so far as that is concerned, I would respectfully say that the approach that is to be preferred, which recognizes that we are concerned here with real possibilities and not simply asserted concerns, is that which has been espoused by my learned friend Ms. Christopher in the course of her submissions. I don't have very much to say about the second of my learned friend Mr. Lynch's first 3 points. But so far as the third is concerned, it seemed to me that he was saying, and respectfully, I take the position that he is really doing so for the first time, that your ladyship ought to, and in fact, he actually said ought have already, to have made some statement of fact relevant to the determination that you have to make so that the parties could address you upon it. And I assume by that he means a response to the substance of what is contained within the affidavit of Dr. Brown and Dr. Warner, going to the state of your awareness of these historical business dealings between them and the court's father. And I was somewhat surprised, candidly, by that submission being made to the court this morning, because respectfully, I don't see that it is contained within my learned friend's written submissions. And it may well be that we would all have been better able to address you on any such issues if that had been raised when we were last before your ladyship. And I don't really see why it wasn't, if my learned friend's position is that you should be making a statement of the facts as you understand them to be, then if you had been invited to do that on the last occasion and had accepted that invitation, then we would all now be able to address you on the content of that factual statement. And I'm a little bit uncertain as to if your ladyship is in fact still being invited to do it, which I do not staunchly oppose, how we are going to proceed from here, given that you're not being asked to do it, as I understand it, in the course of your ruling on the applications, but at some preliminary stage so that you can be further addressed upon what you might say. And it is a point that the Crown has touched upon in the course of our written submissions, by which I mean those filed by the Director and myself on the 7th of June, which is that the parties simply don't know, and I really don't want to start engaging in what I would respectfully characterize as the sort of speculation that Mr. Lynch did in his submissions. The parties don't actually know whether your ladyship was even aware of these historical business dealings between the doctors and the court's father prior to them being spoken to in the course of the affidavits that have been filed by Dr. Brown and his colleague. If in fact you weren't, then that clearly, in my respectful submission, drives a coach and horses through the whole substance of that part of the application that is being made before you. So I don't want to derail this hearing, but it just seems to me that we may be skirting around a question that could quite easily be answered, which I don't object to the court seeking to answer. Mr. Lynch is now saying he wants an answer before this matter is settled. And it seems to me that it might be better to just attack that now. So I'm very much in the...
I have to tell you, as tempting as it is for me to bring some clarity to that, because there is some conflict as to how the court, or whether the court should in fact weigh in with any facts from the perspective, or from my own perspective, I'm going to pause. I'm going to listen to you first. I'm going to listen to everyone, and then I think I'll give you some indication as to how I'm likely to proceed.
Yeah, I mean, respectfully, I'm not sure that I understand what your ladyship has just said in terms of the controversy. I think that, and I hope that I can recall which case, is it the Helau case that your ladyship perhaps has in mind? And I think this is actually a quote that Mr. Lynch took your ladyship to at paragraph 39 of the judgment in Helau.
Paragraph 30.
Correct. It's paragraph 39 of Hilo and paragraph 42 of Resolution Chemicals.
Okay. So are we going to go to Hilo first?
I think so. I don't think that there's a material distinction between what is said in the two, but obviously if my learned friend takes a different view, I'm sure he'll take you to it. But
there's more clarity in Resolution Chemicals.
Well, I want to refer the court to Hilo. If you wish to do something else, Mr. Lynch, then of course you'll have that opportunity. So in 39, after the reference to Porter and McGill, it said the question is one of law to be answered in the light of the relevant facts, which may include a statement from the judge as to what he or she knew at the time. Although the court is not necessarily bound to accept any such statement at face value, there can be no question of cross-examining the judge on it, and no attention will be paid to any statement by the judge as to the impact of any knowledge on his or her mind. So I can see that your ladyship is rightly cautious about wanting to get what impact any facts that may have been known to you had upon your mind in light of what is said there in paragraph 39. But I'm not seeking to get to that point. I think that there is a legitimate inquiry, even before we've reached that stage, as to whether the court was even aware of the facts that are relied upon.
Well, there are many facts that are relied upon.
Yes.
Was there a business arrangement? Was there a business conflict? Was there, I mean, there are many things. That's a very open-ended and very broad proposition that I think I should certainly avoid addressing casually. Either I'm going to be clear and state in answer to the invitation from the applicants any facts as I may or may not have known them or not. But there are many things that are before the court that I don't think should be addressed collectively at all.
Very well, my lady. Well, let me just have a quick look, since Mr. Lynch has mentioned resolution again, to see whether I need to...
Paragraph 42.
Thank you, Mr. Lynch. See whether I want to supplement in any way what I've said about HELAO by reference to what is said. I recall the section that my learned friend took to, and I wonder whether perhaps your ladyship has in mind the comment that the Court of Appeal had there to the effect that the first instance judge had gone too far.
Okay, sorry, we're looking at resolution?
Resolution, section, paragraph 42.
Yes.
So it seems that the Court of Appeal in that case took the view that the judge, the first instance judge, had gone beyond, well beyond, in fact, they said, what was necessary for the fair adjudication of the recusal application in terms of the information that they had put before the parties. And I obviously don't want your ladyship to feel that you're being invited to do that. It just seemed to me that if in fact, and again, I don't want to be the one speculating here, but if in fact the court wasn't even aware of the business.
Let me just bring this to an end. You're going to get no indication from me on any matter in the course of this hearing. I will reserve and consider every point that's been put before me and take it in stages. If there's an invitation for me to address a statement of facts in the preliminary, I will reserve and I will consider that. But if what you're leading to is an invitation for me to make a statement in the course of this hearing, it will not happen.
No, my lady, I didn't necessarily want you to do it now, but equally, I didn't want to end up in a situation where, having had the time to think about what you ought properly to say in light of the statements that have been made, we then have to reconstitute this hearing and potentially all of us address further submissions to the statement of facts that your ladyship is persuaded to make. And that's why I think it is unfortunate, respectfully, that
wasn't brought up earlier.
Exactly.
Mm-hmm.
And I don't really see why it wasn't, bearing in mind that we had the opportunity, I believe in late June, when this matter was listed and then, as it turned out, adjourned. Mm-hmm. And it respectfully, my learned friend is saying that you, and he did, I listened to him quite carefully, say that your ladyship ought to have done this already.
He did say that, I heard it.
And respectfully, he didn't ask you to. I don't see that he's articulated that in writing anywhere. I have looked for it again. And this is the first that it seems to have been raised. So it's unfortunate that we're in a situation where at the moment your ladyship is being asked to decide what you will say, and that if you do say something, it seems quite likely, respectfully, that one side or the other or both will then wish to make further submissions upon the content of what you choose to disclose. And that's an unfortunate situation for us all to find ourselves in, respectfully. But I think in light of what your ladyship has said to me, I should probably just crack on with the other submissions that I want to make at this stage, I hope briefly. And then once your ladyship has had sufficient time to reflect upon what you ought to do in response to my learned friend's invitation, we'll just have to, in the circumstances, take it from there. So the next section of my learned friend's submissions after his 3 preliminary points really was answered in my respectful submission by the submissions that my learned friend Ms. Christopher has already advanced. And as I say, I don't think that I would be assisting greatly if I were to go back through those. I do think that I ought properly to say something in response to what Mr. Duncan has said in response to paragraph 10 of the Crown's written submissions. Mr. Duncan, I think, suggested to your ladyship that there would have been no point raising any objection to the involvement of Mr. Mussenden in the investigation and the decision to prosecute in these proceedings, because had he gone to court with any such complaint at that stage, he would have been told that it was premature, and that if there was in fact a prosecution, that question could be raised in the criminal trial. In my respectful submission, that mistakes the point that the Crown is seeking to make at paragraph 10 of its written submissions. The point surely is this, that if the defendant contemplated making complaint in any forum in the event that he was prosecuted, to the effect that the decision to put him in that situation had been taken by somebody whom he now contends had an animus towards him as a result of not being reappointed by him as Attorney General, then it would obviously have behoved him to have made clear that complaint before any decision was taken by that individual as to whether he should be prosecuted or not. And I do not believe that I shall be contradicted when I say that no exception was ever taken to Mr. Mussenden being the Director of Public Prosecutions with oversight of this case, in the anticipation that he might be the one to make the decision whether or not to prosecute. There was never any approach to him to consider whether he ought, in the circumstances of his non-reappointment as Attorney General by Dr. Brown, to consider recusing himself from that role or delegating the responsibility of taking such decisions to one of his subordinates. And in my respectful submission, that does clearly indicate that there is no substance to this contention, belated contention now, that your ladyship should not be the one to try these 2 actions because there is presumed by the defendant to be some animosity felt by Mr. Mussenden towards him. If there was any substance in that suggestion whatsoever, it would have been raised before now. There would have been a better reason to have raised it before now than there is to raise it before your ladyship, because it was Mr. Mussenden who the defendant would have apprehended was the person making what was then the critical decision, and not the next remove, which is your ladyship now determining the questions that arise in these 2 actions before you. And the fact that that wasn't done, in my respectful submission, clearly shows that that complaint is without substance and certainly not such as to give rise to a real possibility of bias, to use again the language of Porter and McGill. And we can get into arguments about whether the standard is properly to be regarded as a high one or a low one. Clearly, it's not a particularly high standard, nor, in my respectful submission, is it one that should be regarded as being satisfied too lightly for all of the reasons that are clearly set out in the authorities to which my learned friend has referred. But in my respectful submission, Mr. Lynch and Mr. Duncan are trying, in effect, to have your ladyship short circuit the Porter and McGill analysis by suggesting that the informed observer would simply assume that the antipathy which the defendant assumes Dr. Subert and Mr. Muston have towards him for various different reasons extends vicariously to the court. And that is simply too remote, in my respectful submission, properly to be described as a real possibility of bias. The informed observer, as described in the authorities, would not, in my respectful submission, make such a series of contingent assumptions. And it would, in my respectful submission, therefore be entirely wrong for your ladyship to do so. So for those very brief reasons, I respectfully submit that, as my learned friend Miss Christopher has sought also to persuade you, your ladyship should remain seized. I suppose I should confine my submissions to the criminal proceedings and allow this matter to go forward, or these matters to go forward. I note that my learned friends, Mr. Lynch and Mr. Duncan, did not address any submissions to the content of the emails that were disclosed as part of the Crown's written submissions. Yes. I think perhaps I should just say that they really are there out of an abundance of caution in light of the Crown's duties of disclosure, obviously, in the criminal proceedings. They weren't put in as some sort of counterbalance to the concerns which have been relied upon on Dr. Brown's behalf. Mm-hmm. They were put there because it was thought that it may well be that they would be said to be relevant, but I haven't heard anyone seek to rely upon them. So I don't think, respectfully, that it's necessary for me to say anything about them either. But if in fact either of my own friends are intending to say more about them, perhaps omitted them from their initial submissions, then maybe I should say something. But
I mean, I have a question.
Of course, my lady.
I read them. I tried to reconstruct it in accordance with the dates because they don't, I think, flow chronologically when you read through all of them, or at least when I first saw it. But is there anything to be read from the tone of exchanges between myself, then legal aid counsel, and Dr. Brown, then the premier? This would have been so many years after the business arrangement, which is said to have gone wrong between Dr. Brown and the other doctors, including my father. Is there anything that should be deducted from that at all in terms of,
well, I suppose,
whether it's in response to any idea that I've assumed some antipathy towards Dr. Brown or my father, or anything of the like, or should I completely disregard it?
Well, my lady, I say, I hope fairly that we didn't put them in simply as a sort of counterbalance to what has been said, but that's,
but it's there.
I'm sorry, my lady?
It's there. I've read it, and it's
yes, and you aren't obviously obliged to disregard it, and certainly I would say that there is nothing in those emails to give any support to the contention that there was any antipathy felt by you towards Dr. Brown. There is nothing within those emails that suggests anything of the kind. And there isn't, in fact, and I think this really picks up on a question that your ladyship asked my learned friend Mr. Lynch, which with respect he didn't really answer, which is that the evidence doesn't in fact show any antipathy in your father towards Dr. Brown. The most, in my respectful submission, that it shows is that Dr. Brown and Dr. Warner have an antipathy, for reasons that they have set out in their affidavits, towards Dr. Subert. There is not any sound basis for saying, in the evidence that the court has before it, that Dr. Subert has or had, these many years ago, any antipathy towards them. I think the best that my learned friend mustered in response to that question is, why else do it? Meaning, why else cut them out of the deal? And as my learned friend Ms. Christopher said, this is a business deal that did not work out the way that Dr. Brown and Dr. Warner seemed to want it to have done. But that, in my respectful submission, is not a reason to suppose any antipathy felt by Dr. Subert towards either of them. That inference simply does not naturally follow, and it's not one which, in my respectful submission, an informed observer would be bound to make, let alone then taking the additional step of assuming that it's inconceivable that any hostility that Dr. Subert felt towards them would also infect your ladyship. And that's what I mean by this contingent series of assumptions that the court is being invited to make. In my respectful submission, that is not what the Porter-McGill test requires you to do. Yes, you should be cautious, but equally, if you properly apply the test as my learned friend Ms. Christopher has set it out in her submissions, you shouldn't either be sidestepping your duty to hear cases that are assigned to you respectfully. And it's for those reasons that both she and I submit that your ladyship should retain these matters. So I hope that I've answered your ladyship's question about emails. If there are any other questions, I'll do my best to answer those, but otherwise I think I've really concluded my submission.
No, that was very helpful. Thank you, Mr. Richards.
Thank you, Madam.
Shall I now hear from Mr. Deal or Mr. Moody? Or am I going in
Up
the...
to you, milady. And certainly my apologies for not asking if Mr. Deal would mind a very brief interjection from me.
Not at all.
Thank you. Certainly just to keep it very brief.
Yes.
We too would like to associate ourselves with Ms. Christopher's assessment of the law and how it applies to this case. And certainly we also associate ourselves with the very final submission made by Mr. Richards. And we find ourselves in the position to support the position being taken by the first respondent in these matters. We just wanted to put that on the record.
Thank you.
Thank you.
Mr. Deal?
Yes, thank you, milady. Very quickly, or hopefully very quickly, milady, as I made mention it when we first kicked off this morning, you will recall in case number 2017, number 51, a number of occasions, I think my recollection is probably at least 3, involving my learned friend, Mr. Duncan, whereupon he arrived, and by his own admission in relation to matters that didn't directly relate to his clients, who were the clinics at that time, made submissions that were, by his statement, intended to, quote, assist the court. I actually, I viewed that as a somewhat tongue-in-cheek comment. Your ladyship may even remember one occasion when Mr. Pettingill handed up a book, an entire book as an authority, and it had no less than the Trotton Duncan stamp on it. sorry, these points
I must
just.
admit, I don't remember the Trot and Duncan stamp.
You don't remember the Trot, anyway, but so be it. I do actually, somewhat surprisingly, try to make these submissions in an attempt to assist you. As stated by, in my email and as read out by my learned friend, this is primarily a matter for you to determine. And I only wish to make some points, two points. One which is has already been touched on by both my learned friend Mr. Richards and my learned friend Ms. Christopher. And perhaps in relation to that, I can ask you to turn to paragraph 6 of Mr. Brown's affidavit in this matter.
Mm-hmm.
And if I could just ask your ladyship to read it to yourself.
Yes.
The point being made here is, I think very well by my learned friend Mr. Richards, was that this is actually, if I can put it this way, the wrong way round. This is an assertion by Dr. Brown and Dr. Warner that basically Dr. Sabir was trying to, for want of a better phrase, cut them out of the deal. And for that, or in relation to that, according to this affidavit, there was a, quote, great deal of bitterness. And the bitterness obviously was one way. It was from Drs. Brown and Warner aimed at Dr. Sabir. That, as my learned friend Mr. Richards says, doesn't give rise to any reason for Dr. Sabir to be thinking, or far less informing you, of issues that go to Dr. Brown's credibility, honesty, or integrity, if I can use the phrases by my learned friend, Mr. Lynch. If it was in fact the other way around, if it was Messrs. Or Drs. Brown and Warner that were cutting Dr. Sabir out of the deal, then one might understand, at least, the genesis of some form of complaint. But there is quite simply nothing, in my respectful submission, in the evidence to support the contention of appearance of bias. And I say that, my lady, because, and I don't want to get into the issue of statements of fact, because even if your ladyship doesn't provide a statement of facts, and we accept these affidavits at face value, in my respectful submission, they don't get on this issue, they simply don't get out of the starting blocks. And just on that point, if I can ask your ladyship as well to turn to paragraph 15 of my learned friend Mr. Lynch's submissions, where he's citing Resolution Chemicals.
Yes.
It's just the bottom 4 lines, just over the page. There's 2 points to make there. Because thirdly, the fair-minded and informed observer is not unduly sensitive or suspicious. Well, my respectful submission, having sworn the affidavit evidence that there is, and then trying to parlay that into some form of animus, that is being precisely, quote, unduly sensitive or suspicious. And then finally, I should also make the point, my lady, at the very last line. Fourthly, the facts and context are critical. Each case turns on an intense focus on the essential facts of the case. I make that point, my lady, because my learned friend, Mr. Lynch, attempted to, quote, distinguish the Athene authority on the basis that, that should be, it was different on its facts, or it should be distinguished on its facts. That doesn't assist, my lady. All cases of recusal turn on their facts. So that to say it's fact specific begs the question. The second point goes to the case of 2017 number 51, but it was one I intended to bring up. As your ladyship is aware, as your ladyship has commented, there were a number of hearings in relation to that, attended by my learned friend, Mr. Duncan, attended by my learned friends on at least 2 occasions that I recall, Mr. Lynch, and a number of hearings involving Mr. Pettingill. At no time was the issue of an appearance of bias raised by anyone in those hearings. And that is despite the fact that all the relevant facts that could be relied upon, and in fact are relied upon in this case, could have been relied upon in that case for an application for recusal. And can I ask your ladyship to turn to, I hope I had this up on my screen. Yes, can I ask your ladyship to turn to paragraph 53 of the Athene case? It was actually cited by my learned friend. I have to take you back to it, I think, because he made some comments, and comments which actually I would endorse. Does your ladyship have paragraph 53?
Yes, I do, thank you.
So in fact, what I intend to do, my lady, is read this out, but to swap in the facts of this case with what the learned Chief Justice said in that case. In considering what a fair-minded and informed observer may conclude, it is worth noting that no objection whatsoever was taken to, in this case, your acting as the judge in case number 2017, number 51, when you gave a number of rulings back in 2017. Dr. Brown was fully aware of your past relationships and the issues concerning the application for recusal and the connection of the parties, or you with Mr. Mussenden. I refer to this fact not in aid of any waiver, but as confirming the view that the factual situation does not support apparent bias. If a fair-minded and informed observer had considered the possibility of real bias in the circumstances, surely this point would have been taken by Dr. Brown, or in this case by the companies at that time. The reason, or the attempt of explaining away why the application was not made was, as I understand it, well, basically saying that was a company and this is an individual. Well, the lady, if you recall the affidavit filed, one of the affidavits filed by Dr. Brown in that case, he readily states in paragraph 2 of that affidavit that he was the founder of one of the clinics. And in the correspondence that is exhibited to it, he has signed off as that he is the CEO of that clinic. And the issues, as my learned friend Mr. Lynch stated, was that he was, there were issues, and he quite rightly stated, there were issues of, or suspicions of over-testing, which put unpleasantly or bluntly, would be assertions of basically insurance fraud, which are issues, obviously, of honesty and integrity. So those issues were very much alive in the previous case. And had there been the desire or bona fides to make an application for recusal, it ought to have been made and should have been made then. The fact that it wasn't made goes, in fact, if I may say, to bona fides. My learned friend, Mr. Lynch, and he used a much more elegant term, I can't remember what it was, characterized Mr. Potts's tactics in relation to his application that is described in paragraph 51 as basically, I think he said words along the line that it was deplorable to wait until you got an adverse decision before you make an application for recusal. There can be, in my respectful submission, I think there's something your ladyship needs to consider as to whether or not that this is a tactical decision being taken at this stage, having gone through numerous hearings in the 2017-51 case. Your ladyship also recall in that case that there were, in fact, I think with the only exception, again, I stand to be corrected, the only occasion where you ruled against me on that was in relation to the issue of individuals joining on as representatives. But in every other instance, in that matter to date, I think you ruled against my learned friends, save for that one instance. I would regard it as, in my respectful submission, as bizarre indeed if the fact that no application, despite the number of adverse rulings in that case were made, but no application for recusal was made in that case, and now it is made in this case. And as I say, it would be bizarre indeed if any application succeeded in this case, given those facts. Lady, those are my submissions, unless I can assist your ladyship any further.
Thank you. I've seen a number of pop-ups from Ms. Christopher wanting to clarify 2 references. Ms. Christopher, do you want to quickly address that? You're muted. 1 moment, you're muted.
I apologize, my ladies. Just at the bottom of page 8, the Sexsmere reference is a reference to paragraph 10 of Sexsmere.
Yes.
And then the final quotation is from the Hilo case.
So on Sexsmere, you took me from paragraphs 5 to 8. Are you saying no, paragraph 10?
Right. So in Sexsmere, at the very end of my submissions, I just quote one line from a couple of cases. In Sexsmere,
Yes.
that line that I quoted here is paragraph 10.
Oh, I see.
And the last quote I made here was not from the Charles Smiley versus Friend, but it's actually from Hilo, one of my learned friends' cases. And it's at paragraph 2. I don't want anybody to waste time trying to figure out where I got.
No, I appreciate that, Ms. Christopher. Let me just
apologize.
make sure that I properly note it because it can be time wasting.
Also, the cases aren't searchable either, as it happens, as was sent to us. So I had to go and get it.
Oh. So on page 7 of your submissions that reads a paragraph 32 of Sexsmere, you actually want to say paragraph 10, yes?
No, I'm looking at page 8, the bottom of page 8, the very last 2 quotes.
Yes.
Where it says in respect of paragraph 44 of the applicant's submission, and then makes the quote, the court is not making a judgment on whether it's possible or likely that the particular judge was in fact affected by disqualifying bias. That is Sexsmere at paragraph 10.
Okay, thank you.
And then the last quote is Hilo at paragraph 2.
Thank you.
Yes, my lady, thank you. And thank you to my learned friends for the indulgence.
All right, so do we have any responses on points of law from?
May I make a couple of observations, please?
Yes.
First of all,
I'm noting the time. I'm going to take just a 5-minute break. No.
Of course.
But can you give me some indication?
Yes, about 10 minutes.
Okay, thank you. And Mr. Duncan, will you likely be also responding? You're mute. Thank you.
Sorry, my lady. I may have 1 or 2 comments. I'll just confirm. Maybe Mr. Lynch can make them. So that we
Okay.
don't-
I just need a quick restroom break.
Yes.
Miss Christopher, just so you know, you're not muted.
Thank you.
Yes, thank you.
Yes, a few points, please. First of all, can I take you to Lockabale, please?
Mhm.
And you'll need page 478 at letter H. My learned friend in her written submissions, that is Miss Christopher in her written submissions at page 2, makes observation about what is said in Lockabale. It's important, of course, to remember that the opening words of that paragraph that she quotes at page 2 is that it would be dangerous and futile to attempt to define or list the factors which may or may not give rise to a real danger of bias. What is clear is that no case, including this locus classicus, is seeking to identify the factors or features that might lead to bias. The best that can be done is to identify that which can be said does not lead prima facie to bias. And in dealing with that in Lockabale, at paragraph H on page 478, the court, having considered the Pinochet limb 1 and then moving on to what is described there at H, if in any case not giving rise to automatic disqualification.
Sorry,
And not,
1 minute. Mr. Lynch, give me that page number again, please.
yes, it's page 478.
Oh, 417, sorry.
478 at letter H, Lockabale.
Yep. Yes, thank you.
The last half dozen lines at the bottom of that page. If in any case not giving rise to automatic disqualification and not causing personal embarrassment to the judge, in other words, a case, I pause there, where the judge themselves feel obliged to point out, as did your learned sister judge, Charles Etta Simmons, that she was embarrassed and therefore recused herself without any application being made. If he or she is or becomes aware of any matter which could arguably be said to give rise to a real danger of bias, it is generally desirable that disclosure should be made to the parties in advance of the hearing. If objection is then made, it will be the duty of the judge to consider the objection and exercise his judgment upon it. He would be wrong to yield to a tenuous or frivolous objection as he would to ignore an objection of substance. And that's where the paragraph that my learned friend sought to rely upon comes in that we find force in the observations of the Constitutional Court of the South Africans, in the President of the Republic of South Africa and the South African Rugby Football Union. Even though, and it's important to emphasize this, even though these observations were directed to the reasonable suspicion test, not the test that we're applying, which is a fair-minded, informed observer in Bermuda, considering the relevant facts being a real possibility of bias. So it's in relation to the reasonable suspicion test that the expression identified, it follows from the foregoing that the correct approach to this application for the recusal of members of this court is objective, and the onus of establishing it rests upon the applicant. And she seeks to rely upon those two lines and paused for emphasis that your ladyship should consider that. Can I, in that regard, draw your attention, because ancillary to that is what we set out in paragraph 26 and 27, of which criticism has been made, which quotes Porter and McGill. And the only point being made there is that in the application of the fair-minded, informed observer, considering the relevant facts leading to a real possibility of bias test, that is now accepted as being the proper test to apply, that test, there is 2 stages to that test.
It is that hour. 1 minute, please. Yes, thank you.
Yes, I can't make it the point better other than to seek to explain the difference between paragraphs 26 and 27, because it's in this way. In Porter and McGill, Lord Hope made it clear that in considering whether there was a legitimate reason to fear that a judge lacks impartiality, the standpoint of the accused is important but not decisive. What is decisive is whether the fear can be objectively justified. And I come to that in a moment. But it's, in other words, 2 stages. Step 1, can it be said that the defendant has a legitimate concern about bias? In our submission, yes. Step 2, can that legitimate concern, when held up objectively, can that be sustained objectively? And we submit that that is what we sought to do in our paragraph 23, which sets out 7 separate factors, which I need not repeat because I've made them clear to your ladyship earlier. These are the objective bases upon which the fair-minded informed observer would wish to take into account those features, and they are set out there in that paragraph. So it's a 2-stage process, the subjective one of the defendant to start with, and whether objectively that can stand up to the light. So those are the points that we wanted to make about that. And as for Moldova, Croatia 1, Croatia 2 cases, these are, as I thought I made clear, merely examples of how how it works in practice. It's worth observing that in each of those cases, it had to get all the way to the European Court before the court recognized that actually there was a proper bias. So it went through the whole of the appellate jurisdiction in each of those jurisdictions before it actually got that far. My learned friend then makes the point that your ladyship has to have regard to the fairness to the respondents by being robust, as I think she put it. And that's, of course, true in a case where this application might have been made just before the trial starts, or even during a course of a trial, where there has to be a degree of fairness to the respondents. This is at the outset. How can it be regarded as unfair to the respondents if your ladyship were to recuse yourself and, let's say, by way of example, a judge from some completely different jurisdiction came in to deal with the case? How could that be said to be unfair? Ancillary to that, my learned friend also made the point that the test is in some way, as it were, affected by virtue of the fact that this is a small jurisdiction. And in our submission, it is precisely because we are in a small jurisdiction that one needs to exercise that degree of care in deciding whether a fair-minded and informed observer in Bermuda would consider the relevant facts to lead to a real possibility of bias. It is in smaller communities that is more likely to happen. It is a village. Bermuda is a village compared to the United Kingdom or even Jamaica, which has what, 3 million people living in it. the case that learned friend relied upon. So one needs to be particularly careful in a small jurisdiction where there are strongly held views between people. I use by way of example, originally magistrates' courts were conceived to be magistrates who did know the local community back in the 14th century when they were first conceived of, and sat in judgment upon their fellow man. And they were used because they knew their people. That is completely reversed today. A magistrate, in the same way as any other judge, should not have a direct knowledge of the people in front of her, such that it might affect her view of that particular individual who's before her. And in our submission, it is because Bermuda is a village that one needs to exercise. There's not that the test is different, merely that one needs to be particularly careful in the application of that test. The fact in our particular scenarios is that the facts as we sought to lay them out in the affidavits are uncontroverted. Criticism is made of me by my learned friend, Mr. Richards, for not having highlighted the prospect of your ladyship giving us an outline of the facts as you understand them to be at an early stage. Your ladyship will, of course, and as has Mr. Richards, both know that on the 21st of May of this year, I sent to your ladyship and copied to my learned friend an informal submission to deal with the very issues that we are now dealing with formally before your ladyship. If, and what I accept, I didn't ask at that stage for your ladyship to, as it were, identify any facts that would meet the points that we made in that informal approach. It was, of course, entirely open to your ladyship in rejecting that informal approach to say, well, I'm afraid the facts as set out here, I can't help you with because I know nothing of them. They have not affected my mind in any way. And had your ladyship said that, we would perhaps be in a different place. The fact is, if there is to be criticism of me for not spelling out what might be regarded as an obvious way of dealing with the factual matrix that lay behind the submissions that we put in our informal approach, which we regarded as the best practice in seeking to persuade the court to recuse itself.
Mr. Lynch, I think just to put it plainly, you started your submissions, your oral submissions this morning by couching 3 points, one of which was an invitation for me to set out facts. You've not previously done that, and there's no skirting around that. We had a hearing which was adjourned. I don't recall off the top of my head what the date was, but whenever we were supposed to last proceed, that would have been another opportunity for you to have raised it, and you didn't. So that's the only point that Mr. Richards is making, and I think it was a good one.
Well, I'm sure that's right. 24th of June was the hearing, as I understand it, is my note. And I didn't make the observation then. I simply make the observation now that I did write to your ladyship in advance of that.
That doesn't address the point.
No,
the fact that you foreshadowed what your arguments would be in a fully fleshed out recusal application does not address the invitation that you've made now for the first time, something that could have been dealt with in the case management stage of this hearing, an invitation for me to set out facts, which would then have the parties or give the parties the opportunity to address me one. You did not raise that until the hearing proper, which is this hearing.
I agree, I didn't.
That's just factually correct.
Of course, I'm not suggesting it is anything other than that. And for that, of course, I must take responsibility. Having said that, what I do say is that it's not the first opportunity that the court have had to consider the facts. And the facts are peculiarly known to you, other than that which we have set out in the affidavits. And what I set out.
It always appeared to me that I would be addressing the facts as they are before the court. I have affidavit evidence from your client, and I will take that affidavit evidence on the facts as they are uncontroverted. That was always what I understood I would be invited to do.
And indeed, that is what you are invited to do.
I don't know if we've frozen or you've paused.
No, I've just paused.
Okay.
Look, let me be clear. If that is a proper criticism, and I'm not suggesting it isn't, that I should have raised this issue earlier, then I accept that responsibility, and I should have. All I'm saying is that the facts, as stated in the affidavits, were stated in an earlier correspondence with your ladyship.
They were, yes.
And it's something which, if your ladyship felt that it was something could be dealt with in the way in which Mr. Richards has suggested, by simply making an assertion as to whether the facts are borne out or not, it seems to me that that is something that could have been done. And it's my fault for not having raised it with your ladyship at the last occasion. But if I may say so, it's not just for me to raise. It is something which the court could and should perhaps have considered also, as to whether or not there is any substance in the factual background which can only be known to your ladyship.
Yes, Mr. Lynch, thank you.
Those are the points I wish to make. Thank you very much.
Mr. Duncan.
Well, lady, I have no further submissions to make.
Okay, thank you. As I indicated earlier, I will obviously reserve. I will come to state in writing what my decision is, whether it be in respect of the invitation to give facts before a ruling, or I may revert with a ruling. I'm going to consider all that I've been invited to consider, and you will, in the regular course, hear from the registrar or someone on behalf of the registrar as to how I have decided what's in front of me. I do think, however, that we should deal with a return date, because the fact of the matter is there's still a criminal file that's in front of me, and I cannot, as if it were a civil matter, just simply adjourn. I think I have to set another date for return on the criminal file. And so it seems to me that this matter can go into my, what I am now terming my October session. I have matters coming before me on the 1st of October at, which I believe is a Friday, at 2:30 p.m. So I can at least put this, the criminal matter, in front of, so that's indictment number 9 of 2021. And give it that return date. Now that's in Sessions House, courtroom number 1.
Would your ladyship consider an alternative date? I shall be out of the jurisdiction on that day.
Can you not have someone hold for you, Mr. Lynch?
I could, yes. If that's not convenient to you or the court, then of course I can have someone hold for me.
No, because I do these monthly. It would, so it's always on the same arraignment. I have various matters before me, various criminal matters before me, and they come on a monthly basis on the same day as arraignment session. So the morning matters will go before Justice Simmons or another judge. The afternoon matters come before me. Just so
Can I do it remotely?
Sorry?
Could I appear before you remotely on that matter?
No, I will be sitting in Sessions House.
Right.
So,
Sure.
I mean, the expectation is that Dr. Brown would also appear.
Of course he'll be at your ladyship's command. My concern is that he should not have to travel unnecessarily, simply to appear only for the matter to be adjourned to another date, if that's all that is to happen. I mean, I appreciate, of course, that there is an obligation in relation to his bail to appear as and when required to do so. But you'll appreciate that he's a man of some advanced years, and avoiding unnecessary contact by travel and entering it outside of his normal circle would be to his advantage. And so I'm anxious that we shouldn't.
Right. Dr. Brown is ordinarily resident outside of Bermuda?
Yes.
I understood, where have I seen it? From some correspondence from you, Mr. Lynch, I believe it was.
Yes.
That the reasons, yes, I see it. Some correspondence sent to the court. It was sent to the senior magistrate. It's on the criminal file on the 15th of January. That the reasons why Dr. Brown was not appearing before the court personally is because he had not been vaccinated, and that he was due to receive his second dose within a time frame which would have surely passed by now. And that
Yes,
was
he has had his second dose.
so. I mean, what's the basis for? Let me just propose this. I'm looking at the hour. If you want to make an application for Dr. Brown to be excused from appearing personally before the court, you can make that application on the papers.
Certainly, I can do that.
Yes, and if you're going to rely on any facts that warrant some affidavit evidence, you can liaise with the Crown as to what position the Crown takes.
Yes, of course.
There may be facts that are uncontentious and you can put it in some correspondence, or there may be facts that require to be deposed. But there should not be any presumption that the norm is going to be for, in the criminal proceedings, for the hearings to be dealt with remotely. It's certainly not the norm, which obviously you would be well aware of.
No. I'm quite clear that that shouldn't be the case, and that's not what I'm seeking to achieve. What I'm mindful of is that if it is simply a question of a place marker in a court calendar for the sake of the necessity to have such a place marker, and nothing is going to happen on a particular.
I might have a ruling by then. I might want to see what's the position. All of those hearings are for the purpose of case management.
Of course, of course.
So, I mean, they're not just arbitrary dates for us to robe up and meet.
No, and I appreciate that, and one would hope that that is not going to be the position. But as a practitioner, as I'm sure you will recall yourself, having been a practitioner not that long ago, that there are all too often cases where we turn up and nothing happens because nothing can happen for whatever reason. And I'm anxious that he shouldn't have to travel unnecessarily if that is all that is going to be the position. If, on the other hand, something of substance needs to happen, then of course there is an obligation on him to be there. But
I make no indication to you other than to say that all these cases have to be managed. The court manages criminal cases. If we were talking about just the civil proceedings, fine, that's a different matter. But the criminal cases, every single criminal case assigned to me is being actively managed. Every single one.
I have no doubt that that is true.
Okay. So I will adjourn. It is being adjourned to Court 1 in Sessions House, but that does not prevent you from making an application on the papers if there's any need for some special consideration. Okay.
Thank you.
All right.
Could you kindly confirm the date, milady?
October, and that is.
That doesn't concern Mr. Moody, I don't think.
No, that, I mean,
the
that,
ladyship is listing the criminal matter.
No, if let's suppose for a moment that seemed to be an opportunity for me to deliver a ruling, then if that's the case, then
it is in that
communication
respect,
will be
right?
made to all the parties. But I'm just simply giving a return date for the criminal matter, and that's all that I have in mind in setting this date at this point. Okay.
I'm guided, milady.
Now, it may also be, Mr. Lynch, if you are keen to avoid that which you've just described, you may want to liaise with the prosecutor. And if there's, whether it be in relation to disclosure or if there's an agreed position, that makes practical sense to both the Crown and the defense, then by all means, write into the court and let me know what the position is in terms of disclosure and all the other regular things that would be considered at a mention hearing in criminal proceedings. Okay?
Yes.
All right. So bail is extended. And judgment is reserved. Is there anything else I should consider before we adjourn for the day?
No.
No?
No, thank you, Melanie.
Okay, I want to thank everyone for their submissions. It was helpful from every single person who addressed me. Thank you.
Adjourned.
Good afternoon.